made a ruling and emailed that yesterday to the parties. So anything for today?
I made changes to the orders and emailed those to Ms. Baldwin yesterday. Assuming she emails me a signature page today, we'll get that over ex parte.
Okay.
And I've seen Your Honor's email and opposing counsel's, and I'll review both. And I assume we'll be sending that over for signature likely later today.
Okay.
Thank you, Your Honor.
Sounds good.
Ken Anderson for
Thank
Mr.
you.
Day. Frankly, Your Honor, with the holiday, I believe that Michael Trotter and I have reached an agreement. However, my use of technology, I couldn't get proposed orders up to the court. So I don't know what the court would like to do, but indications are that Mr. Trotter and I agree on the language of the orders that I've drafted.
Yes, Your Honor. I just have, and I just wanted to ask the court for one piece of clarification, if I may, regarding a birth date that I forgot to request the last time. So if you're willing to hear that, and Mr. Anderson's willing to agree, the one thing that I wanted to get added potentially is the birth date of the child is a point of friction every year. So I was hoping that the court would entertain allowing my client the even years for the child's birthday, 15th through the 18th of August, and the opposing party, the odd years, same dates.
Mr. Anderson?
Your Honor, I haven't had a chance to confer with my client, but since the even year has already passed, I think we can work that out, Your Honor, rather than taking the court's time.
All right. So that's what I would suggest that you do is I'll go ahead and just strike it from today. And you work out that final matter and get me orders. If not, you'll need to note it back on, and then we can go from there. Okay?
Thank you, Your Honor.
Excuse me, Your Honor. With the guardian ad litem reappointment, I guess I'm second guessing myself. I put it into the order modifying the temporary order that the guardian ad litem was reappointed. Would the court prefer that we go through the whole order appointing guardian ad litem form again, or what would the court like?
Yes, it needs the full guardian ad litem order. It clarifies duties. The guardian ad litem can use that. And so, yes, you would need that.
Thank you, Your Honor. Okay.
Thank you.
Bye-bye.
We have Ms. Bliss. We have Ms. Powers. And do we have Ann Height? Yes. Okay, we have Ann Height. I'll be just a minute. All right, so this is an interim review. And so at this time, I just want to check in with Ms. Height. If you could give me an idea, have you been successful contacting folks and those particular matters?
Yes, I have, Your Honor, and I did file an interim report for the court's consideration. I filed that on the 26th of August.
So in regard to that, Ms. Powers or Ms. Bliss, and I'll be real honest, I don't know if I just missed this yesterday, but I seem to, or things just didn't upload until early this morning because I was here yesterday to work on all the files. So, but with that, Ms. Bliss, Ms. Powers.
Your Honor, I did receive Ms. Height's report. At this time, there's no motions before the court or any request by either party. I know my client has some concerns with the report. She was hoping to file a declaration clarifying some points, but at this point, we've received the report. I don't believe anything else is necessary for today.
Ms. Powers.
Thank you, Your Honor. We have received the report. We've reviewed it. My client is in agreement with the recommendations, but it's correct that neither party has a motion before the court, so I don't think there's anything to do today.
Okay. All right. So thank you, Ms. Height, for getting that filed, and I apologize for not seeing it. But with that, I will just, at this point, look to for the motion and the next time that this matter is on, and then we will go from there.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Van Tongeren, v. Van Tongeren. We had Ms. Gilmore. I don't see Mr. Anagnostou.
I see him. I believe he's on.
Okay. Mr. Anagnostou?
Yes, I'm here, Your Honor. There.
Okay. All right. Let me get a couple of things real quick. This is on for a request for contempt. And with that, counsel, go ahead.
Yes, Your Honor. This matter is relatively simple and straightforward. Respondent was ordered to sell the community property in December of 2022. When he failed to do so, we ultimately went to trial in January of 23. At the time of trial, the court ordered for him to either refinance or sell within 120 days of the court's oral ruling, resulting in a deadline of at the end of May. It's now September. We have no evidence that he even attempted to refinance whatsoever, and the home is still not on the market. He provides a declaration, frankly, several weeks late, that shows really no efforts to comply with the court's order. He's indicating that he may speak with someone that's willing to sell the home. But again, based on my review late last week, the home is still not on the market. So there's been really no efforts here. And frankly, the parties, to the detriment of the community, frankly, we're now in the fall, which typically summer months are the best months, but the home simply just needs to be put on the market as soon as possible. As detailed in my client's declaration, respondent is a high wage earner. My client is disabled. She frankly does not have the funds to continue to bring this matter before the court to get compliance. She spent over $10,000 at trial simply trying to get this matter closed that has been pending for 8 years. The community property, the home, was purchased during a 25-year long-term marriage. So we are asking the court to grant the contempt, order the home to be placed on the market immediately. We're asking for substantial award of attorney's fees. At this point, we're asking for $5,000, given the fact that my client had to pay to attempt to have him personally served. It seemed he had moved out of the home at that point. We were then forced to bring a motion for service by mail. So we are asking for $5,000 in attorney's fees, and we are asking for the court to set a review to ensure compliance. And if he continues to fail to comply, we're asking that my client is allowed to put the home on the market.
Mr. Anagnostou?
Yes, Your Honor. To begin with, my client, Mr. Van Tongeren, is here in my office. This is an order to show cause, and so I wanted to make sure the court was aware that he is complying with the order to show cause. He's here in court via, he just doesn't have access to Zoom, so he's sitting here in my office. So if the clerk minutes could reflect that he has made it to this hearing. If you need an affirmation from him, we can get that. With regards to the motion, the home is sold, and we filed a supplemental declaration. I'm not sure if Your Honor got that. It was late last week, but he has been in negotiations to get the home sold, and the home is sold. It's in closing at this point, and Ms. Van Tongeren is going to be paid. He has been working on a home, trying to get it in a position where it's marketable. There was substantial repairs that need to be done. During the trial, he, indicated, and the court was well aware of, that he was going to need to, there was some bathrooms that were gutted during the marriage. There was a deck that was taken off. There was a old oil tank in the ground that needed to be resolved. I mean, there was a lot of issues at this household. The court heard all of that. Anyway, he has gotten it sold. It's in closing, and Ms. Van Tongeren is going to be paid her judgment. And so the other issue is Ms. Van Tongeren comes here with unclean hands. She hasn't complied.
I object.
Stop, Mr. Anagnostou, stop. Ms. Gilmore?
I have to object. He has not brought in any sort of motion for contempt regarding to the transfer of property. I don't think that's properly before the court. And as the court's aware, it's not a remedy for contempt to allege another contempt.
Go ahead, Mr. Anagnostou.
No, but it's a defense to raise unclean hands. And my client is raising unclean hands in his response because Ms. Van Tongeren had 60 days to get her stuff out of the house, and she still hasn't gotten her stuff out of the house. So really this timeline hasn't begun to tick because it didn't start to tick until after she removed all of her personal property, and the personal property is still in the home. So that's a defense, a response to a motion, an equitable motion for contempt is unclean hands. The petitioner's in this case has come in and hasn't complied with the court's order. So we asked the court to not find my client in contempt. He has been diligently working to sell the house. The house is now sold. Ms. Van Tongeren will be paid. It's going through closing. And she hasn't complied with the court order. So those are our responses, Your Honor.
Ms. Gilmore?
First, looking into the allegation of contempt, my client timely moved out of the home within 60 days of the court's oral ruling, which was difficult for her to do, given husband's failure to put the home on the market or refinance and her limited resources. I'm looking to the decree itself, and it basically just provides that my client was to take her personal property. She has taken her personal property, and it's unclear to me what property he's alleging she's left in violation. But simply, if anything's left behind, it's his at this point. And there's specific language: the court shall retain jurisdiction if any disputes arise over household personal property. If there was a problem with property being left behind, it should have been brought, but simply this was not the reason that caused delay. He simply refused to comply with the court's order. And I looked to the court's minutes or the Odyssey record, and I don't see any declaration indicating that he is sold. And frankly, I just don't believe it at this point without that information. I haven't been served with a declaration. And again, we were forced to bring this motion for contempt. And but for that, even if he has attempted to sell, it would have required us to bring this motion. Moreover, at the time of trial, there was an appraiser that he called that testified that the home was worth $480,000 and indicated there was no issues with the home being sold. So the court contemplated that testimony when ordering him to sell within 120 days or refinance. So we asked the court to find contempt and award fees.
So I reviewed the files and record, and based on that, the court finds the following. The respondent has failed to show any significant attempts to comply with the order of the court. There may be some repairs that needed to be done, but all of that would have been taken into consideration at the time that it was before the trial court when making the ruling. And then to talk about one company that may have interest is not an intent to list the case. Maybe it's now sold, but that showing has not been made. The court at the time of the ruling, as I said, 120 days would have had the necessary information to set the timeframes. They did so. He has failed to follow that. Therefore, the court does find a willful and an intentional violation of the court order, and the respondent has failed to take the necessary actions. He knew the requirements and has failed to do so. So therefore, is in contempt of the court order. The respondent can purge the contempt by 1, immediately listing the property for sale on the market by September 10 at 5 p.m. 2, the respondent shall provide notice to the petitioner within 24 hours of the listing, including the name of the agent and company the listing has been made with, the value of the home the property has been listed for, and the requirement of the agent to keep the petitioner notified of any activity of the listing. Any and all requirements of the decree of the dissolution. So there may be some additional ones that I have not said. So at this time, again, maybe it's been sold and maybe it's been sold for the value. I don't know. But the court is going to grant the request for the amount of attorney's fees because the court does see this as a very willful and intentional violation. And so the $5,000 in attorney's fees is due within 14 days of today's date to the attorney for the petitioner for the necessity of having to bring this contempt motion.
Can
Your Honor, can you
Can I inquire, Your Honor, if you received the declaration from last week?
Are we talking about one that's from August 29?
Correct.
I do have it.
Okay. Thank you.
And this whole thing about this remaining personal property, I'm not even going to address that here. There's not a motion. And as far as has been said, Ms. Gilmore has indicated that there's nothing that she's claiming that's left in the house. So I'm not even going to go there.
entry and review date, Your Honor?
We can put it on September 17.
Thank you.
All right, there are 2 matters on. First is the final GAL report, and the second is a motion to compel. We have Ms. Baldwin, we have Ms. Turnbull, and we have Ms. Klopp here in the courtroom.
And the court had indicated already that you're setting over the final GAL review 1 week.
Correct.
Okay. So as to the motion to compel,
So let me clarify in regard to the GAL review. I did receive your motion to adopt, but again, the court doesn't find that it was timely for all the paperwork to get done and responses to be done. And so that's why I'm not considering it today and setting it over. Okay.
Thank you.
All right. So that's what's going on there. And then I have the motion to compel. Go ahead, Ms. Baldwin.
Thank you. So on the motion to compel, we're specifically looking at, and this is to compel, and again, a request for fees and sanctions in this case, regarding a couple specific pieces of information that are really crucial to being able to show a number of underlying factors in this case. One of those first items is the Google account. Although the account is provided, what the account shows is that it was substantially edited prior to being provided. It showed that information was edited, information was deleted. There was a repeated takeouts, which is the sort of Google term for redacting information and removing it from the file. And then the file was downloaded essentially 19 different times in order to confirm that all of those takeouts were successful. As we know, sometimes you'll have computer data that's in one place and then another. And so there was sort of an assurance that the other party wanted to make sure that all of the information that they didn't want shown was removed from the file. So, and you can see that as attached as Exhibit B to my client's declaration of July 23rd. She also changed the settings within her Google account to make this possible. So again, this is not a whoopsie. This is not a mistake. This is a very intentional, methodical person who is going through making those changes, changing those settings, and then removing the information that would be harmful to their case before forwarding that information on, making material changes. Similarly, we had requested communication, essentially her social media communications. There's a significant dispute about whether some relationships continued. And what you see is essentially Mrs. continues her, you see her stop her communication with boyfriend on one date, and then her social media app usage with Messenger and WhatsApp then explodes thereafter. And she doesn't provide that information at all. And in this case, she says, oh, well, that's all work related, and so I don't have to provide it. And my client says, absolutely not. We have nothing from not even a single employer that says this is in any way employer related. It would be very odd for an employer to use an app like WhatsApp for communications. And then when you look at the communications themselves, that doesn't make any sense. Her communications, you can see her using this, you can see her using it to message on March 6th is really when this starts. That doesn't align with when she started with that employer. So again, that doesn't make sense if she's saying this is work related. Similarly, you can see that the messages themselves, again, we can't see the messages. That's part of what she's not providing, but you can see her messaging at 11:30 at night, 1:15 in the morning. Those aren't work times. That's not when she's working. So again, that doesn't line up with, oh, this is work related, so I don't have to provide it. So again, we have somebody who's not providing these critical pieces of evidence, materially changing them. In the same vein, we have Snapchat, which is another social media app where she claims, oh, well, I deleted it, so I don't have access to it. But the app itself, and again, my client shows that she was active on the app as of April 11th, and this request was served, and that's 14 days after our request was served. So she deleted it after our request was served. So again, withholding evidence, destroying evidence, or deleting it. So we're in this situation where we have a number of critical pieces of evidence where my guess is that they would show things that Mrs. does not want seen, that they would prove things that she doesn't want proved. And so in this case, she's just saying, well, I'm just not going to provide it or claim it comes from other people, or claim, essentially that these are communications with other people, but I won't show that. So in this case, that causes substantial issues. So what we're asking the court to do is first order her to provide it. We believe that it's most likely that she does have a copy of the original Google account, that she removed it, looked through it to find all the things she wanted to delete, and then deleted them. So there is a chance that she has that original file that should be provided. Similarly, she should be required to provide the Snapchat as well as the other social media apps like WhatsApp. Those all need to be provided in full. There's just no excuse for not providing those, especially when we have no verification that they are from her employer or in any way associated with her employer. And at this point, she's had more than a month to procure that. So again, just not really an excuse there. Finally, we should set a date to review compliance. If she has not complied and not provided those things, then at that point, it's not sufficient to simply issue a financial sanction, because then what that means is that parties can simply buy non-production. If something's going to harm you and all the court is going to do is fine you, great. For some parties, that would be an excellent choice. I would choose not to produce this if I know that the cost is $1,000 sanction. Many people would say worth it. That's a great, that they're willing to pay that cost. So simply a cost alone is not enough, especially in a case like this. So the court should set a review date, and if it's not provided and not provided in full, then the court should then make findings that are associated with the request. And those are findings to the findings in the negative or contrary findings that the court will authorize the court to do. So depending on what she provides and the quantity of what she provides, I think then I would propose findings if she does not provide all of the data that we have requested.
Go ahead, Ms. Klopp.
For the Google account on March 27th, I had said that Ms. Winkles had asked me to pull a Google takeout to see if I was tracking my location. And I put that information in a declaration on March 28th. I didn't even get the discovery request from Ms. Winkles until April 1st. So I wouldn't have known prior when I took that takeout. And when I did do that takeout on March 27th, all I had deleted was an old iPhone that said it was still attached to my account. I had numerous other things that I had to get for them, my Instagram, my Facebook, which they have all records of that I had downloaded. On April 11th, I sent my Google takeout information to Aaron, and I even provided the email that said there was errors. When I was downloading it, I'd open the file and the file was blank. So I don't know what was going on, but that's why it was essentially downloaded so many times. I never deleted anything or intentionally tried to withhold any information on my Google. I don't have any of those files. I had a computer that my ex had given me last year. And when we had that crash for the software on July 19th, my Adobe wouldn't work on that old computer anymore. So I had to finally use the Lenovo laptop, and Brody had always, my son wanted computer. So I deleted everything off that computer and made it a kid's account for him on it. So he has that laptop, but there's nothing on that. For WhatsApp, I didn't provide anything for WhatsApp because the number 9 I can't even say it, says to provide in which it's related to any way to this action. And there was no way it was related at all. It's all work related. I use it for travel. Also, when I have clients overseas, it's easy to contact them with a WhatsApp. And then for work, I have an employee that lives in Paris and she comes for the summer and visits. And the only way for me to talk to her without racking up a ton of money on my phone bill is through WhatsApp. I had deleted it in 2023 at the end of the year because I thought she was done coming over and working. I reinstalled it this summer for clients for travel, and also she came back over and did summer work with me. So I was talking to her for that. And Paris is also 9 hours ahead. So when I do talk to her, it's usually late at night because it's morning time or afternoon for her. And I do use Teams for work. That's our main form of communication, but with the limitations in different countries, they can't always access Teams. So that's why I would talk to her on WhatsApp. But with Teams, we do hundreds of messages daily and calls. That's our main form of communication, as my job is based in California. So I work remotely. My boss is in communication with the works attorneys since we do have NDA for clients and it's a privacy. I've talked to my employee about her pay and all sorts of stuff on WhatsApp. So she emailed me last night and said that she did try to follow up with the attorney last night, but with it being a holiday.
Okay, and I'm going to object to the hearsay, and this isn't in any declaration anywhere.
I would agree. You can't add that in.
Okay. And then I did, there was a protection order that was filed that went along with number 4 and number 5 request for production. In between going from Aaron to the other attorneys, there was, I guess, a docket notice was never filed. And so I filed that this morning and I haven't had time to serve them as the court opened right before this, but that is set for September 23rd. But that would kind of go with number 4 and number 5 request for production. I wouldn't be able to pay anything. I'm obviously having to do this by myself. I can't even afford an attorney as I've spent so much on fighting past allegations and everything. So I don't really think anything should be awarded for that.
Anything else?
No. I've tried my best to do what I can with what I have and limited resources without an attorney. So I'm just trying as good as I can.
Ms. Baldwin?
Thank you. I want to be clear, just because you delete an app on your phone, it doesn't mean that the data is gone. The app is just a conduit to essentially the server of that company. So all you have to do is reinstall that conduit. The data is still there. So this idea that I deleted it off my phone, that does not mean that all the data is magically disappeared. It's still there. You reinstall the app, all the data is still there with your same passcode. In the same way that it works with your computer. If you delete your Outlook off of your individual computer, it doesn't mean that your email address has disappeared. You can get onto a different computer and access your email. So I just want to kind of provide some of that clarity. Again, she says, well, I'm not going to provide my Snapchat because I deleted it April 11th. But here she even acknowledges that even if her attorney didn't give it to her right away, that she had the request by April 1st. So well, hey, I deleted it. Then you deleted it after you are just fully acknowledging you deleted it after receiving our discovery request. She makes no response or no answer as to the files that are labeled Tombstone, as to the Google information and the calendaring information. So again, really doesn't have an excuse for why that happened and why these settings are changed, why the deletions are showing. So again, real concerns there. Nothing whatsoever to show that these communications are work related. She said, well, I've signed an NDA. She could have provided that very readily and easily. Didn't. Not a scrap. And here we are. This was filed in July, and here we are in September. There's been plenty of time to provide a scrap of anything from her employer showing it's work related, and there's not a scrap. And so again, it's just her word of, hey, believe me, this is work related, when none of it really lines up. None of it really makes any sense that she would be doing this in this frame. And my clients provided gone through essentially the data and provided you with essentially, here's Exhibit A, here's what she did, here's Exhibit B, here's how she did it. This is the information we're seeking. And it is imperative that we obtain the information and have it, or that the court make those findings. Because again, parties benefit when they just withhold information and say, oh, well, that's going to be really negative for me, I'm just not going to provide it. So in these cases, it's critical that the court make orders that penalize parties appropriately when they don't provide.
So the court understands that you are representing yourself. At the same time, you have the same obligations under the rules as anybody else, including attorneys. And that I have the information that's in front of me that has been presented and provided. And that's what I have to look at and base things off of. So based on the files and record, the court does not believe the statements of you as the petitioner, and the court expects you to comply with the requested discovery. Based on the notes from the 26I conference, the needed information was discussed. Now, that information will be provided within 21 days of today's date. The court does grant the attorney's fees of $1,000 to the respondent for the necessity of having to bring this motion, and that's to be paid within 60 days. I understand your financial state. At the same time, when it costs the other party money, that's where that comes from. If the requested information is not provided as ordered, then the court will consider additional fees as requested by the respondent, including the penalty for the failure to provide unaltered documents. In addition, if the documents are not provided, the court will consider the striking of the responsive pleadings or strike any testimony by you as a petitioner on the topics that are being talked about. So if I understand correctly, and correct me, Ms. Baldwin, if I'm wrong here, I have Google, Snapchat, and WhatsApp. Is that correct?
Yes, Google, Snapchat, WhatsApp are the main ones in this case.
Okay. Do I just do the downloads for it? Is that the information that Ms. Baldwin's?
So what I would suggest is Ms. Baldwin, and Ms. Klopp is have another conference, telephone conference to talk about just what she needs, because I'm not involved in the discovery part of it, so I don't know what has or hasn't been provided. But have that conference again with Ms. Baldwin, and that way it's clear as to exactly what she's looking for.
Okay.
Okay.
We can do presentation.
So we have the GAL review and that I didn't address today, that I just set over to the 17th, but you said you set your matter to the 23rd.
Yes.
Maybe the 24th.
It was whatever that Tuesday is. They
Yeah,
said 3 weeks
September
from-
24th is the Tuesday. So did you
Oh,
put
yeah,
it
they
on the
put
23rd?
so that I might have to go out and talk to the clerk.
You'll have to refile that with the
Okay.
correct date because it'll be sent back. So why don't we just set these matters, including the GAL review and the presentation of the motion and your motion that you have onto the 24th. That makes the most
Okay.
sense.
Okay, so everything over to the 24th.
Correct.
Okay, very good. All right, very good. Thank you.
Thank you, Your Honor.
So I have Miss Bliss that is here. Do I have anyone else present on this matter?
Carly Salazar.
That's my client, Your Honor.
Oh,
And Carly, you can go ahead and mute your microphone.
Okay.
Anyone else on this matter? For the record, I don't have anybody in the waiting room. All right. Ms. Bliss, I read your motion and just so the record is complete, I did consult with Judge Evans to make sure he had no objections to my making the ruling, since he made the original ruling and he did not.
Okay.
So I always check with the original signing judge. So I had your motion, and based on that, as well as CR 60, I don't know if you want to add anything to your motion.
No, Judge, I think my motion and memo adequately outline our position. So I'll turn it over to the court at this point.
All right. So based on the files and record, as well as the CR 60 as identified in the memorandum of law, the motion was timely brought. The court does find it necessary to vacate the prior court order for the following reasons. One, there was no proper motion brought by the respondent. And two, the court does find the respondent had improperly withheld information as to his address. Therefore, the court shall vacate the temporary parenting plan as requested and will allow the matter to proceed to hearing.
Thank you. And I did note in Odyssey that Mr. had filed, I think, at least some docket notices for purposes of a hearing tomorrow. I think largely that is moot given Your Honor's ruling now. I would make a pitch to strike the hearings for tomorrow, but I'll defer to the court.
All right, I sign the order.
And is Your Honor willing to strike those hearings scheduled for tomorrow, or do I need to?
Yes.
appear Judge Evans?
Yes,
Okay.
they are the same or related, I guess.
Yes.
So
Okay.
I will strike those.
Very good. Thank you, Judge.
4-08, Gavino v. Cook matter. And we have Ms. Baldwin and we have Mr. Zandy. Then we have Ms. Turnbull. All right. So let's start with the presentation of order.
Oh, we reached an agreement and I believe Mr. Zandy signed off and we sent that over ex parte.
Okay.
Yeah, and that's the most recent order. The order that we have not entered, to the best of my knowledge, is that one from the hearing on July 23rd. So that would have been the order on hearing as well as the order on contempt.
The order on hearing here that was signed off by Mr. Zandy. So I will go ahead and sign that one.
And is that the most recent order, Judge, from 2 weeks ago?
Says August 21 for Ms. Baldwin's
Yes.
signature, and the 26th for you.
Yes, that would be the one that was as a result of the last time we were before the court on the initial GAL review. Now we agreed to that one. There's one floating order out there that was not stipulated to or signed off on. That was the one from July 23rd hearing, which set in motion the hearing from 2 weeks ago. So there's that's the one I think that has yet to be entered in the court file.
Okay.
And that was filed, the proposed order was filed back on August 8th in Odyssey.
My objections a short time later, August 15th.
Okay. All right. Well, it sounds like it's taken care of. So.
Oh, no, I don't think. So we agreed to the August 20th order, the one you just signed. There is an order prior to that that still needs to be addressed.
Okay. I'm just looking through what I have here between paper copies and electronic copies. So, okay. So with that, that's what I was looking at. So let's go ahead and address that.
I'll let Mr. Zandy go first since he's making his objection.
We'll start with that order on hearing, Judge. I have two primary objections to Ms. Baldwin's proposal. The first is on paragraph 2. And that relates again to an issue that we've been addressing over the past 2 months or so. Now we're asking that a provision be entered that states the children shall have no contact with landowners pending GAL input on August 20th. Again, that was the hearing that we just had and agreed to the form of that order. Given the uncertainty of where potential abuse may be occurring, additionally, children shall not be left by the father with any third parties, including but not limited to sleepovers, social events, or situations where the child could pose a threat to others or others to him, pending GAL input. And I think that was the specific order of the court. We just asked that it accurately detail my proposal.
Ms. Baldwin?
So on that, the court did specifically order no contact with Landon. I'm fine if we add the language to pending review, or pending changes by the court. What I don't want to have is to create some sort of odd gap. So I just want to avoid that. And on the issue of third parties, I'm fine with adding that. I just would have that language match the language that the August 20th order used. I think that Mr. Zandy and I both agreed to that language. So I think that that's just easy language to use.
And the only thing too, I think in that same vein is related to, wasn't the intent of the court to have that just apply to Kyson for the third party events such as the sleepovers, or does that apply to both kids, Jameson as well? And again, Jameson's in an age where my client tells you he likes sleepovers, birthday parties. He's now approaching teen years. That's what they do. He's shown no signs that I'm aware of being impacted the way Kyson has. So I guess I will leave that up to the court with potential clarification from Ms. Turnbull today. But perhaps that applies to just Kyson for the time being, is to not allow for Jameson to be left out of events he otherwise would enjoy and participate in.
And I don't think the court intended to limit it. I think the court met both children, at least at this point.
When I ordered it, I was intending both. I also understand why the request. At this time, I want to leave it as both. I understand that limits the other child, but at the same time, there's just too much unknown.
Yeah,
so, Ms. Turnbull, I don't know if you have any thoughts on that.
I have not investigated anything in relation to Jameson on this with this current appointment. So that's one of the questions I had for the court. I know that particularly father has some concerns that he would like me to pursue, whether or not the court would like me, to further investigate that. But I don't have any particular input specifically for Jameson at this time.
So let's leave it with both at this point.
The secondary to that, Judge, paragraph 3, counsel had included that my client provide proof of dates of attendance. My understanding was proof of compliance. The court wanted that information by August 5th. I believe we filed and submitted that a day or two early, 3rd or the 4th. Nonetheless, the court has the information from the counseling services. I just don't want to get in a situation where we're back in front of court.
Hold on, Mr. Zandy. Unfortunately, we have to stop the system and restart it.
So I'll start back from the beginning of that. Paragraph 3, court had ordered that my client was to provide information related to her counseling services as a domestic violence victim. In that, we did that, we provided that, we filed a copy of that from the counseling agency and provider that shows she's in compliance, she's doing what she's supposed to. If you look at the proposal made by Mr. Gavino, he has stated that he wants proof of dates of attendance. I don't think that was what the court had ordered. I think you were more primarily concerned with proof of compliance, which we've given you. So I ask that you strike the proof of dates actually attended.
Anything further on that?
From me, yes. The issue here is the court ordered therapy, not just successive intake appointments. When we have proof of compliance letters from, for say, domestic violence counseling, they list the dates that they attended. So it'll say they are in compliance. These are the dates that they attended therapy or treatment, what have you. And so the concern is when you look at the letter, it's essentially a timeline of what Core Health did, but it isn't anything really about treatment received. So this isn't a compliance letter. It's Core Health saying, well, she did an intake and communicated with us on this date. And then we did this, and then we had a conflict, and then we did this intake, and then we had an issue. So then we switched people. So the concern here is that we have a long letter that isn't a compliance letter. And the fact that it doesn't even look like a compliance letter should be concerning. So again, most compliance letters have the dates of treatment. And I think that that's reasonable in this case when even Core Health isn't sort of shooting straight. And we should just have a look. And all I'm looking for is to just confirm that she did treatment, not just that she went to an intake and then a year later did another intake and then 3 months later did another intake. That's not actually receiving treatment.
Well, again, this isn't necessarily treatment, this is counseling. So to gauge this as opposed to the perpetrator of domestic violence, which I would agree with that analysis, is apples and donuts compared to being the victim in domestic violence. So I think that's the difference. This is also the case where providers and my client alike gave you information in the July hearing initially that stated she's been to different providers trying to seek these specific services. Some of them provided it, some of them didn't. And so she's kind of, again, off to that personal counseling side of things, as opposed to you need to have treatment once a week for the next 56 weeks, like we sometimes see with domestic violence perpetrators. So I think that's the difference here, why it becomes a little bit problematic.
Okay. Well, at this point, anything further on that?
No.
Okay. At this point, understanding why, and maybe that's what I see, and maybe that's why I'm thinking. But I think at this point, because of the concerns of everything going on, I would like to see the dates just to get a sense of how often. And so I would like to just see as well as the compliance.
Try to investigate those.
Okay.
And I think that resolved Mr. Zandy's issues.
Yeah.
I mean, correct me if I'm wrong. I can provide an amended order to Mr. Zandy, and then we'll just send that in ex parte. I don't think we'll have any further issues.
Okay.
Then lastly was the order on contempt. This should not take long. Paragraph 4, father made allegations pertaining to 2 specific areas and alleged violations of the parenting plan. Now we would ask that those be included in that order of contempt. Counsel and I spoke about this several weeks ago. I thought that was agreed. If not, I'll let her address. And the second one, and more importantly to me, is paragraph number 5. I don't recall the court denied Dad's contempt motion and awarded my client fees. I don't recall there being, the court finding there is suspicions of non-compliance. I don't think that was the case. I believe he did deny it in full. I think that was the basis for the $500. I think there was some suggestion that contempt was made kind of in furtherance of the motion that Dad was asking to be heard at the same time. So if I'm incorrect on that, feel free to change however you want to do that, Judge, but I do believe that the language that I have proposed in my objection is accurate of the court's ruling that day.
Ms. Baldwin?
So it'd be page 2, number 5. The court finds that there's suspicions. That's just exactly what you said. So that's exactly what I put in the order. Is that there wasn't sufficient evidence. The court understood why there was a suspicion, but there wasn't sufficient evidence. So that's why I put it in the way it did, because that's what Your Honor said. And it wasn't. So he objected as to number 4, but it wasn't a parenting plan. That was a violation. They were separate orders. They weren't violations of the parenting plan. They were different orders within the file that she had violated. So it is appropriate that 4A does not apply because it's an other order. So that's more appropriate. So to me, I guess I could say that the court didn't find contempt as pled, but it was not a parenting plan that we were trying to find the contempt in.
So in regard to the idea of the suspicious part of it, anything further?
No.
Okay, suspicious part, that's what I agree with Ms. Baldwin. What she has is what I had said. So that will remain as set. And then I think the last part that Ms. Baldwin was talking about, it just needs to reflect what she has indicated. So I think the rest of it is
sufficient.
Yes.
Very well.
All right, Mr. Zandy and I will just work those out, and then we can just send them next Friday.
Okay. Make sure I don't have any orders in here.
My guess is I feel like we put it over, and so my guess is they might not have cycled at this point within the file. So I'm going to make changes to the other order. I'm fine with, we'll just send them both.
Okay. All right. So that brings us to the GAL matter.
Do we want to get input from Ms. Turnbull first on this, Judge, since this is again, a pretty fluid situation over the past month and a half?
I do have the report that was filed and the supplemental filed on August 29th. With that, I think that would be appropriate. Ms. Turnbull?
Yeah, so I also, this last week, went to visit Ms. Cook's new residence. She has moved to her grandparents' home, and that seems like an appropriate place for her and the children to be. The grandparents have a nice home out in the country. There's plenty of room for the children to play, rooms, beds, that sort of thing. So I don't have a concern about that home. And in terms of the parenting plan reverting, as we had discussed at the prior hearing, I think that would be appropriate. I know that that all parties would like to have a definitive answer in terms of Landon and where this concern in regards to Kyson is coming from, and I think it's too premature. We need to get some time in with Kyson and Ms. Rosen to have some time to work together. Hopefully that will provide some more clarity, but at this point, we just don't know yet. And I think that at this time, we just need to wait and be patient and err on the side of caution in terms of protecting the children until we have more information. So I would suggest that we check back in 2 or 3 months and see if Ms. Rosen can provide us some sort of update and go from there, and just let her kind of be the guide as to that. And is there anything else in terms of my report you'd like me to give an update in regards to?
I don't think so. I think we're good at the moment. So let me just I want to start with Mr. Zandy in part because I know he's his client's making requests for changing where we're at the moment. So let's go ahead.
And I appreciate that, Judge. We have reviewed Ms. Turnbull's initial kind of findings and suggestions on this case. Largely agreed to revert back. Now, this is a case where you, again, kind of put a Band-Aid on this from 2 weeks ago. Said, all right, we're just going to treat it like an extended summer vacation that we would have with one parent or the other. That's what the parties have largely done. My client is certainly agreeable to go back to the way it was. And again, I cannot stress this enough. We simply do not know what's happening right now. And unfortunately, we're now a month and a half later. Still no idea on that. I like the suggestion, think that's appropriate. Let Ms. Rosen work through this as however long that needs. When we do find something out, I certainly trust counsel and myself to be proactive in that, bring it back to the court's attention when that time comes. In the meantime, I think that's the best we can do. So my client is suggesting that the court is agreeable to adopting what Ms. Turnbull's recommendation is from last week. She has moved in with grandma and grandpa. We've given you information on that. They're good people, good residents. Kids are comfortable there. Grandparents are comfortable with them. They've lived there before. It's in the same school district. Each kid has their own room, and I think that's very important given the circumstances. And they have their own facilities. So again, I think that's probably a good thing. I think that makes the most sense. As far as the requested changes, they're pretty minor, but important nonetheless to my client. And we do ask that you contemplate that. The first is, if you are inclined to pick up and adopt Ms. Turnbull's recommendation, my client would normally have Tuesdays. We ask that if the court is going to do that, that she be permitted to pick the boys up from school this afternoon. She's available to do that. And again, that kind of flows with what the normal arrangements for these kids has been over time. So that would be picking them up from one at Butler Acres, I believe. I think Jameson is still at Butler Acres or now in his first year at Calhoun. Nonetheless, pick the boys up and proceed as normal. Also asking you to consider, and it's not a direct first right of care, but it certainly kind of dovetails with a first right of care. Specifically, this is the case, and you know this, you've heard extensive argument that dad delegates a lot of his parenting responsibilities to the new wife. My client details for you in her declaration the concern that as it pertains to school starting last week on Wednesday. Again, she was readily available to take both kids to school. Dad was not. Dad says, well, you can take the younger child to school, but the wife is going to take the older child to school. And this is one of those traditions that my client values, holds pretty dear, which is take the children to school every day. Dad says, no, essentially you can take one because it's easier for them, but you're not going to take both. What we're concerned about with this, and this is kind of in addition to the school, is the counseling appointments, the doctor's appointments. Again, dad is gone. Dad lets wife take the kids to these types of things when my client is available. These parties need to learn to communicate and co-parent. If one is not available, they need to rely on the other one to do that. They need to put the differences aside, act on the best interests of both these kids, and proceed as such. Dad hasn't been willing to do that. Dad sees this more as a divided front where, okay, if I can't do it, I'm gonna let my wife do it. And that's caused significant problems, as you can imagine, over time. So I do believe that both parents, if the other one is not available, the other one have the first right to take the kids to those appointments. They communicate accordingly over the parenting app about who needs to take the kids to what, and they proceed from there. Second of all to that is this counseling issue. And again, this is one where parties, and I think this was set in motion, I'll let Ms. Baldwin respond. My memory on this says this was one where the court initially a year and a half ago or so ordered that parties essentially alternate in taking these kids to their appointments, specifically back then counseling. Ms. Rosen is seeing Kyson on Fridays. That was the only day available to her. Everybody agrees that needs to happen. As opposed to dad taking, and that's dad's day, as opposed to dad taking the child to counseling every single Friday. And we would ask again that both be treated equal in that. And that again, they alternate on a week-to-week basis who takes Kyson to Ms. Rosen's office for his needed treatment. And again, I think that's a similar vein to that right of first care, and it also needs to be included. Insurance information. We understand that dad will be getting private insurance for the boys effective October 1st. My client is asking, because this has been a sore spot and source of contention for these people for the past several years now, that if that happens, dad gives her the information, gives her a copy of the insurance card so that she can do that, so she can operate again on a similar vein as dad. Boys are currently on state medical. I understand that once dad gets his private insurance through his employer, state medical will be secondary to that. But nonetheless, these parties need to exchange insurance cards as they become available. We've already addressed my client's concern with both kids being left with third parties. I think that clarifies that from the prior order. So I think that issue is resolved. And that's specifically, what we're asking on that. Otherwise, these kids deserve both parents. We want these kids to be healthy. I think both parties have that common goal for that. There's just remains that dispute as to what the source of potential abuse or exposure is coming from. And my client has told you her case time and again, and Dad has been adamant in his case. And I think this is just where it comes down to Ms. Rosen and her area of expertise, and hopefully shedding some light on that over the course of the next couple of weeks, probably more realistic next several months, so that we can come back and address it as we need to. Needs to get resolved. Everybody wants to, especially these kids, especially Kyson in this one. I think this does that. We do agree with the rest of the recommendations made from Ms. Turnbull, and I'll turn it over to counsel.
Ms. Baldwin.
Thank you. Again, there's substantial concern in this case. My client is asking that we not revert to the 50-50 plan, and that does not make sense with the facts that the court has before it right now. We have folks that we have Mrs. now moving in with the grandparents, but grandparents are not so separated from Landon. You see that in the text messages that my client provides, where grandparents are texting Kyson about Landon, doing with Landon. So this is a concern that this is a home where you have a family system that is not supportive of Kyson and Kyson's safety. We also see that in that this entire family took a family vacation with Landon. So again, a family system that will not keep these children separated because they just don't believe it. They're not going to believe it. And there's nothing that, frankly, I think anyone can say that'll make that change. The counseling records that we have from the older child speak to what's going on in these homes. We look at because we have Jameson going once with mom and once with dad. So you have that stark contrast of what it looks like for the child in those homes. And I invite the court to really look at the tenor of both of those counseling notes. In the appointment with the mother, we have her openly crying and visibly upset, it says. She made the child's appointment about her. She put the focus on her. She talks about being embarrassed of her own child. And this is Jameson, the older child, who's having less issues between the two of them. And we know that she's unstable, lacks transportation, instability in housing, and in life partners, a significant rotating door, that she's currently pregnant. None of those things equate to a supportive household for Jameson and Kyson to A, be safe, and B, assuming they're safe, to get well. That's not a household that can manage it, frankly. That's contrasted with the appointment that my client attended, where he's supportive of the child, he's supportive of counseling, he's stable, and the child talks about his feelings openly. Versus mom's appointment, where the counselor even notes kids pretty shut down, that kids just kind of shrugging his shoulders and giving one-word answers. But that's not what happens in dad's appointment. In dad's appointment, child is able to talk about his feelings and specifically talks about how he doesn't like how in mom's household, people are talking poorly about father, and that older child's getting to the point where he's getting really frustrated by all the negative talk that mother and her family do. So there's really a stark contrast, and the court has to really think about
Hold on.
I apologize for interrupting, counsel. What counseling records are, and I know we both submitted our information somewhat late last week, what counseling records are being referenced right now?
So those are the August 5th and August 23rd counseling notes from Jameson. We filed those.
Okay.
I'm showing that from the filed August 29th. Is that correct?
That's correct.
Okay.
So again, we have huge concerns, and you have a real disparity on what's happening in these two households. There's sort of this like, well, I don't have 100% proof of what's going on. That's not the standard. It's almost as if we've decided that the standard here is beyond a reasonable doubt. That's not the standard we're dealing with. It's a preponderance. And the question is, on a preponderance level, where is the weight? We have a threat assessment. We have counseling records. We have school records that all talk about Landon, that all talk about those issues. And we have admissions by the mother and her family that these things occurred. And we have this child's behavior that's exploding. So we have these huge amounts of weight. The only thing on the other side is an email from before one of the children was born. Those don't equate. The weight is just not there. So we'd have these substantial concerns. My client believes, again, he doesn't want to cut the mother out. And when you look at the counseling records, that's specifically what he's saying is like, look, I'm just trying to keep my kids safe and make them well. And frankly, keep Kyson from being a person who ends up on the offender docket. My client says what makes more sense at this point is to make my client primary and give mother weekend visitation. My client should have at least one weekend a month because that's time when kids aren't in school and you need time for bonding, but that makes the most sense. On the first right of refusal request, that does not make sense here. The level of interference that the mother wants to engage in is minute by minute. And she talks out of both sides of her mouth saying, well, he gave me one child and let me take that child to school, even though it wasn't her time. And so he absolutely accommodated her request there. But how dare he not give me everything I wanted? My client didn't have to give her anything. And her complaint is, I didn't get everything I wanted, even though I wasn't entitled to it. That's not somebody who is trying to be difficult or trying to make her, trying to cut her out. So again, sort of this ridiculous request and a ridiculous request for just a massive amount of engagement with two people who just clearly don't get along. That is a recipe for disaster. The court should not do that and should not engage in that. As far as the insurance, my client says, of course, he's frustrated that it's only brought in reply. So my client doesn't get an opportunity to respond. But my client's like, of course, I'm going to give her the insurance information when he gets it. But the court should make that order 100% unilateral because my client says he's been in the exact same boat on the other side and has been incredibly frustrated. So the court should just make that order very clear. And I would just suggest 14 days, within 14 days of receipt of insurance information, you have to provide it to the other side. That makes it very simple and it applies to both sides. As far as counseling, again, my client agrees to alternate who takes them and is frustrated that, again, mother makes these statements and my client's in the position of being like, yeah, you're right. It's alternating. But that means that if the alternating date falls on Mrs.'s time, my client is the one that takes them. And that's already become a problem where she only wants to alternate when it benefits her, not the other way around. Alternating means alternating. So again, my client has no issue with the alternating, but it applies to both parties. And then as far as third parties, I believe we have agreed language at this point, and it seems to be reasonable and keeping the children safe. So in this case, again, on a preponderance standard, on a safety planning issue, it makes sense that these children reside primarily with my client. To err on the side of caution is to err in a way that is safe for the children, stable for the children, and puts them in a household where they can be healthy and where they can heal.
Ms. Turnbull, I'm going to go ahead and ask you at this point, do you have specific input at this point or thoughts?
Yeah, my thoughts are that I would like to look into the issues of the counseling a little bit more. I have concerns that we make a decision based on the notes from just 2 visits. Those could be cherry picked. I'd like to speak to the counselor to have a little bit more information about that. And I would like to know a little bit more about mom's counseling to find out how much counseling she's done and to know a little bit more about that. I do think Ms. Baldwin makes some points, but I'd like to know more information about that before I weigh in one way or another. And before we disrupt.
Okay, go ahead.
The history.
So, and then Mr. Sandy, I'll give you a chance. With that in mind, you made a recommendation based on how things are at the moment. Would you prefer that status quo as it is at the moment be maintained until you have an opportunity to look at that?
Yes.
All right. Mr. Zandy.
And again, counsel keeps calling this preponderance standard, and I agree, but preponderance is much more than an allegation. If that was the standard in the family law docket, we would be going on allegations and assumptions based that are oftentimes self-serving, which it has been from the onset with Mr. Gavino. who has consistently said these things are happening. It's all the fault of this 16-year-old, and there's nothing to back that up at this point. That's the point of the GAO. Again, and if we look at that, preponderance is much more than a neutral GAO who states at one point, at this time, the investigator has found no evidence that Landon has had any sexual contact with the boys, such as that doesn't get you to the preponderance standard. You've also got these other issues of dad that, again, counsel conveniently glosses over or doesn't mention at all. There's drug and alcohol history, which is significant. We've given you that information between dad and current wife talking about their back and forth, their times in Las Vegas, doing cocaine, getting drunk.
I'm gonna object because this is way outside the scope of the argument, and then I didn't have any opportunity to address any of this.
It's right in the declaration from a little over a month ago that details.
So hold on. This is where this gets complicated and why I typically ask for a motion with all supporting at the time. So at this, Ms. Baldwin, I get it and I understand. I do know it. I did read it. So let's move on. I understand the issue in dad's house too. So
we have these third parties again, who the kids have been routinely exposed to, not at mom's house, but dad's house. We're giving you that information again about these text messages, about my client finding out after the fact that these kids are left in random homes with random people again over dad's weekends, where he doesn't communicate with mom about that. These are all very troubling. So although it suits his kind of his idea of what he wants to have happen, and it's absolutely this person who I'm not affiliated with, when there's been no evidence to support that, to disrupt these kids' lives, take mom away based on allegations that are completely unfounded at this point, to take her from being, which again is complete in this file, from being the primary caretaker up until recently when dad filed his petition, mind you. Take that away and have her get a couple of weekends a month when she's done absolutely everything to comply with these court orders. Again, I think is making certain assumptions that just aren't there and don't meet the preponderance standard. There's nothing there to suggest that. There's just as much information that shows these kids may have been victimized while under dad's watch. And again, we have nothing to substantiate or support that. The emergency plan that was put in place by Butler Acres, what does it do? It separates 3 different kids, I believe, Kyson and 2 others, because there was inappropriate things going on between these kids in the classroom, on the playground, and the after school activities. So again, if we look at that, there is a lot of different potential sources here of abuse. We don't have any confidence in any one of those that's been identified. It could be one of them, it could be multiple sources, it could have happened in their dad's watch. We just simply do not know. So if we adopt Mr. Gavino's recommendation, just say, great, well, I keep the kids under this air of suspicion of could have been a family member. Because again, neglecting the fact that there is a lot of potential sources which could have caused this. And the preponderance standard is there for a reason. And at this point, we have no valid information that shows where this abuse is coming from. We won't have that until Ms. Rosen gets involved. So I'm somewhat surprised to hear, again, Ms. Turnbull say, well, we can keep the status quo that was set in effect 2 weeks ago. And that's not what the recommendation we got in an email from her was several days ago. And what does that tell me? That tells me we simply do not know. And we need some answers to that before we start changing these kids' lives, start uprooting them from what their consistency and normalcy has been, especially given these circumstances when one of the child is being victimized. We can all agree to that. We can all agree we want that stopped. We just don't have any assurances where that abuse is coming.
So here's what the court's going to do at this time. As I said, when there's new information flowing in, and this is a fluid scenario overall of what's happening, what is going on, and that when the court made the last ruling in regard to the schedule, we were at the end of summer, and that so I looked at it at that point as kind of an extension, as it may be of a summer additional time with dad. And that's where, when there are filings that come in late and new information, it makes it difficult. There is no knowledge at this point of where the incidents have occurred, what has happened. And obviously that does need to be figured out. And, trying to figure that out, there's a question in regard to the family member. There's a question about, did something happen at dad's? There is no knowledge at this time as to what is or isn't. So what the court wants to do at this point, because of the late filings, is reserve. I know that's not what you want to hear, but that's what the court's going to do today. And set this matter over to September 24. And I would ask that if there are any additional filings, any additional information that you want considered by Ms. Turnbull and the court, that you get it to us timely and have the ability for Ms. Turnbull to investigate any issues that may come up. And so the court is not going to make any changes at the moment, understanding this is temporary. The court is not making a ruling or a decision. This is reserving a decision to allow some additional time. So with that in mind, again, I'm going to go ahead and set it to September 24. I want everything to Ms. Turnbull. Let's see, we're on the 3rd. No later than September 11. And then Ms. Turnbull, hopefully you'll have an opportunity to get everything done and filed by September 18. And if you would go ahead and just email a copy of your report, file it, obviously, email a copy. My system is different and I never know when things are going to upload. So if you could do that, that'd be great.
Yeah. Would Your Honor just, I think it's easier, instead of saying timely, if you would just give us a drop dead date why the lawyer's filings are by this date and no later.
I think that would be.
I thought that's what I did, but.
Well, you said to Ms. Turnbull.
September 11 for the attorneys.
All right, very good.
And to Ms. Turnbull. And then I wanted Ms. Turnbull to hopefully have a supplemental by the 18th.
Very good. And then does Your Honor want to, we talked about, Your Honor said you wanted the respondent mother in this case to provide the dates of her counseling, and it sounds like Ms. Turnbull wanted those as well. Do you want to provide a date certain for those as well?
Do you think you can get those by that 11th?
I will try my best.
Okay, so September 11.
But that might be difficult just because she's been with 4 or 5 different providers.
Okay. See what you can do.
I think they're all with CORE though. So I think they're, because that's what the letter from CORE goes through. And then with the court reserving and maintaining all orders that are currently, including the no contact with Landon, are continue pending that date.
Correct. I am going to rule on the additional things that were talked about because I want clarification. That is as far as the first right of care. The court is not going to be granting that at this point. I think there is too much conflict and issue, and I'm not going to put children in the middle of that. I do agree that the parents need to get this figured out and work together, especially with issues that are happening. The alternating who takes Kyson, that will be granted. I think that's best practice. And then in regard to the insurance information, that request will be granted, but it will be unilateral and to turn over the information within 14 days of receipt.
Right. And then I'm going to let Mr. Zandy draft this one since I've drafted the last couple.
Okay.
Deal.
Okay.
Well, I think probably what needs to happen on this ASAP too is that we find a time to hopefully all 3 of us get together and talk to Ms. Rosen at one. I just think that's where it's going to come down to. And that probably makes the most amount of sense. We could do that within the course of the next week, which might be overly ambitious, but That's where I see the information coming from. Otherwise, I just see everybody, I mean, everybody's made the pitch. We've said it time and again, and we're just kind of in a limbo, not knowing, which is a terrible place to be, but that's kind of the reality of that. So to get any useful information by the 24th, I kind of see that being the starting point of where we go.
Okay. All right.
And then we'll just do presentation on that same September 24th. All right, very good.
You can get it done earlier. That'd be great.
All right, very good. Thank you.
All right. Thank you.
You.
Steven Swenson for Tracy Driver, Your Honor.
All right. And we have Linda Osborne. So at this point, my concern is that this is a motion for contempt. And within that request is a request for jail time. And that because of that, the court does find it appropriate, Ms. Osborne, anytime there is a request for jail time, the court does inquire of whether or not you would like to have an attorney.
I would absolutely like to have an attorney. It is very difficult to find an attorney, and I've been putting feelers out for an attorney, and that's why I made a motion of continuance, Your Honor.
So at this point, can you give me a sense of, well, I'm just going to grant the attorney. I looked at the financial. So are you looking to retain an attorney, Ms. Osborne?
Yes, I have had inconsistent employments over the last year, and that is why I have not made my financial obligations. I have secured employment through the end of January, and so I hope to have an attorney within the next 6 weeks.
Okay. So here's what I'm going to do based on the financial information that I have is go ahead and appoint an attorney for you. If it becomes a question about the financial part of it, there's a possibility the court may request reimbursement. But at least at this point, we can try to get somebody appointed for you. Does that work for you?
It does.
Okay. All right. So that takes some time. It's not going to happen today. I apologize, Mr. Swenson. I haven't heard from you. You understand the issue and.
Mm-hmm. Yes, Your Honor. I was just wondering if Ms. Osborne is able to make any payments in the meantime.
Yes.
Okay. All right. So with that in mind, I will go ahead and my judicial assistant will work on trying to locate an attorney for you. It does take her some time to do that. And so her name is Autumn Terry, Terry. She'll be the one that will be contacting you once she locates an attorney for you. Okay.
Thank you very much, Your Honor.
So what I'm going to do is set this over to October 1. That way we can get an attorney on board and take care of any thing else that needs to happen. And then, so any questions at this time, Ms. Osborne?
No, I appreciate the opportunity to get an attorney. Thank you.
Okay. Mr. Swenson, anything from you?
No, Your Honor. Thank you.
Okay. All right. So that's what I'm going to be doing today and setting the matter over to October 1.
Thank you.
All right.
Thank you.
With that, go ahead.
Yes, Your Honor. This has come before you on a couple of occasions, and it's been continued to today's date. The issues are, and what we're requesting is that the court order Mr. Blowers to disclose the mortgage password so that my client can pay the mortgage. She hasn't been able to pay the mortgage. She's been collecting the mortgage payments and saving them. But she's concerned at some point that the mortgage company is going to go forward with a foreclosure if the mortgage isn't paid. She already paid to get it out of foreclosure to save it once, and she doesn't want to lose the property. But we need help from Mr. Blowers. He needs to do whatever he needs to do. I mean, he put a password protection on it after my client made a couple of payments for some reason, and it's created a significant issue. We've tried to work this out, and we can't do it without his cooperation. It's my understanding he's on the road as a truck driver and out of the area a lot of time, and we just can't get cooperation from him. He needs to do whatever he needs to do so that my client can make the mortgage payments. So that's our first request. Our second request is that we're asking for a judgment against Mr. Blowers for back spousal support. He hasn't paid one dime of the spousal support. At this point, it's been 14 months through September. So we're asking for a $14,000 judgment against him so that we can garnish wages or do something to get payment to my client to help her with the bills, including the mortgage payment and other things that were a part of the temporary order. So he hasn't made one spousal support payment. We're asking for a judgment through September. And then we're asking for him to set a day and time to pick up his personal property, in particular, a truck that is just deteriorating in my client's backyard, being devaluing the property. We want it removed off the property. If he doesn't want it, then my client's already made arrangements to have it towed off they would salvage it, or a tow company would take it for just the value of the vehicle and get it off her property. And if there's any other personal property, we've asked that we exchange a list, and then we can set an agreed time when Mr. Blowers can pick up his property, but he hasn't really made a request that he wants his personal property. But if he does, that's up to him, and we just like an order from court that counsel participate in trying to get the personal property resolved. But in particular, we want a day time that he's going to come and either remove the truck or some kind of acknowledgement from them that my client can dispose of it, one or the other. And finally, we're asking for attorney's fees for having to bring this motion. Mr. Blowers is full-time employed as a truck driver, makes good income, and my client has limited income. She is part of a counseling service and does in-home counseling for disabled children. But we would ask for an award of attorney's fees. We'd ask in our motion for $2,000 for having to bring this motion.
Mr. Trotter.
Yes, Your Honor. So I'm asking that the court deny the order compelling password for the following reasons. One is that, as you know, in around August of 2023, the court ordered my client out of the home and ordered Mr. Ignazio's client to pay the mortgage. It wasn't until March of 2024 that we heard from the opposing party requesting the password. And I have worked with my client to obtain that password. However, I can't advise my client to violate the online user policy of Freedom Mortgage, which strictly prohibits sharing the password. It was my understanding that I communicated to Mr. Ignazio's office that the mortgage company has authorized his client to call the mortgage company, and they would in turn contact my client for the authorization. So I'm not sure why that wouldn't suffice, and I certainly can't advise my client to violate the company's policy. We're happy. We've been trying to assist. It took months and months and months before we even got a request for password. So, I mean, in essence, effectively, his client did not obey the court's order to pay the mortgage because it took so long, nearly 8 months before we got a request for password. So no payment was made. With respect to the spousal support, I understand the court ordered that my client simply just cannot afford it. That's just a fact. He is a truck driver who was, ordered by the court out of his home. He works very, very hard to keep up with his current expenses and just simply cannot afford the spousal support at this time. With respect to the vehicle or the truck on the property, my client has no place to store that. Again, as acknowledged, he's on the road, and he can't afford to pay spousal support. So how is he going to afford paying for storage of that property at this time? I just simply ask that that vehicle remain where it is until this case is decided. I also asked that the court deny the attorney's fees because, again, it took so long to get here. With respect to the password, we've attempted to facilitate working that out. It just hasn't worked. And I provided those reasons. So for that reason, we asked the court to deny the request for attorney's fees.
Mr. Anagnostou?
Yeah, just briefly, as indicated by my client's declaration, she made the payments. She was ordered to take over the house in September. She made the payments up through December when he then password protected it. So January and February, she wasn't able to make the payments. March, we started this trying to get this resolved, and which ultimately led to this motion. So we have acted timely, and he needs to do whatever he can he put the password on it. He needs to take it off or make arrangements for my client to be able to make the payments. And then with regards to spousal support, it's due, and we're entitled to a judgment so that we can seek collection, and which will start the mandatory interest rate for non-payment. And Mr. Flowers has just been deficient in making any kind of spousal support payments. And again, we ask that the court set some kind of reasonable procedure for Mr. Flowers to retain his personal property if he has any personal property he wants off the property, but in particular make arrangements with regards to this truck. And again, we would ask for attorney's fees. Thank you, Your Honor.
Mr. Trotter?
Yep, just in closing is...
Oh, sorry. I apologize.
Yep.
Jump back. All right. Anything further from either of you?
Oh, yeah, just that we have attempted to work out an arrangement that is that it would require, the mortgage company requires his client to contact them, and then they in turn contact my client for authorization. That's the authorized way of doing things.
So at this point, this matter has been set over and set over. And as far as where we're at with this, based on the files and record and what's been stated, as to the compelling the respondent to disclose the password for the mortgage service, I would just at this point ask that your client, Mr. Anagnostou, make contact with the company and make the request to have the access, and that she do that right away, and that in 21 days from today's date, if they have not been able to make contact with Mr. Trotter's client, then the court will compel that he either remove the secondary step or whatever it is that changed things so she could not make the payments, that he remove that or provide the password, whichever it may be. So that's what we're looking at as far as that part. Hopefully the company will just work with her and get that set up as a separate matter. Clearly on the judgment for past due spousal support, if I recall, that was the $11,000 that is being requested. So a judgment will be granted for that, plus interest at 12% for the non-payment of maintenance. And so that maintenance been ordered. So to claim now he doesn't have the money, I was fine suspect. In regard to the Ford Ranger XLT, the court orders the respondent to pick up the pickup within 5 days of today's date. And if not done, then the petitioner can sell it. It needs to get taken care of. And then in regard to the attorney's fees, again, this matter's been set over several times, it seems. And so based on the necessity of having to bring this motion, the court does grant the request for attorney's fees of $750 for, again, the necessity of having to bring the motion, plus $750 for the delays, because I know that was a question and issue at one time as well. So for a total of $1,500. Judgment is granted for the unpaid attorney's fees, or for the attorney's fees with interest accruing of 12%. So I'll just grant a judgment for that $1,500.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Do you want to set it on for presentation, or do you want to just note it up if you have an issue?
If we could set it on, that would prompt me to get it done. So
We could set it to September 24 if that works for the two of you.
that works for me. I have a week of trial that, but I should be able to work around that.
Mr. Trotter, September 24.
System's moving slow today.
Because of the week of trial, I may ask the court to set it over one more week beyond that, which would,
We could do it October 1.
yeah, I appreciate that.
We preferred, Your Honor.
Okay. All right, that's what we'll do.
Thank you, Your Honor.
Thank you.
Thank you. This is Mr. Anagnostou. Twyla Corey is the guardian ad litem. And then do we have Cheyenne Acevedo?
Yes, Your Honor, I'm here.
Okay. Be just a second here. All right. So I did not receive a response from Ms. Acevedo. Did you file anything?
Yes, I did file it Friday. When I filed it, I didn't realize Monday was a holiday, so I thought it would be before you today.
So I'm assuming at this point, then you're requesting a continuance. Is that what you are doing?
Yes, please, Your Honor.
Okay. Mr. Anagnostou, obviously, if it was filed on Friday, it wouldn't be an odyssey. I've not read it and I would not have any response to it. Do you object to any continuance?
No, Your Honor, as long as we continue the restraining order until whenever this matter gets heard. I would like to point out to the court that this is the case that's set for a week of trial, the week of the 23rd. I'm not sure if we're going to set this over 2 weeks for me to get the documents and continue the restraining order, the protective order until then, or 3 weeks to the start of trial, or it's.
That would make the most sense, is to just combine it in with the trial.
That's what I would think, but.
So Ms. Acevedo, any response to that? So basically they're requesting to, with it being set over, that the restraining order remain. You are currently set for a trial the week of September, you said 23rd?
Right, 23rd.
Wow, that cover really does match. Huh? I know it does. It's right in.
So it would make the most sense at this point to go ahead and set it with the trial for the moment. But what I would do is set it on for October 1, just with the idea that if your trial goes and it's taken care of, you can strike the first.
Okay.
But if it's not, then we can go ahead and address it on the 1st. Does that make sense, Ms. Acevedo?
Yes, Your Honor.
Okay. All right. So. All right. So, Mr. Anagnostou, if you could go ahead and get me an order extending or a new order, whichever may be. And then we'll go ahead and
And the order extending is to October 1.
October 1.
Right, with the understanding that it may be resolved during trial.
Correct.
Okay.
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 There's something needed.
I will get that circulated.
11:30 trial assignments to want to be in 2 places at once.
Okay. All right. So that's what I'm going to do. Ms. Anagnostou, get me an order. I will go ahead and set it over to October 1. And then we'll go from there.
Okay.
Ms. Acevedo, make sure that anything you file, that you get a copy to Mr. Anagnostou. Did you do that?
I did, in fact, email him a copy of what I filed with the court. I sent it through actual mail, not email, so that's why it's taken some time, but he should have it in the next day or two.
We need to communicate via email.
Okay. So send a copy by email, okay?
Okay, I don't have all of my filings on a computer. I don't have a computer access, so I don't have anything in email, and I lost my attorney, so everything I'm having to do is in paper, unfortunately.
Okay.
You just need to get it to me timely, so.
Yeah, you need to make sure to get it to him right away. So go ahead and are you here in town or are you somewhere else?
I am up north. I have a job interview this afternoon in Chehalis.
Okay, but typically are you here in the Cowlitz County area?
Yes.
Okay, so why don't you find out where Mr. Anagnostu's office is? It's pretty easy to get to, and just make a copy of everything you filed and get him a copy.
Okay.
Okay. All right. All right. That's it for today.
Thanks, Your Honor.
Thank you, Your Honor.
All right. We have Mr. Zandy here in the office, or excuse me, courtroom. And then we have Ms. Holder. Yes. Okay. All right.
Well, thank you. I already represent the petitioner moving party, namely Lindsay Ahern, here on my client's motion for temporary orders as it pertained at the time of filing. If we submitted this at the beginning of August, big issue at that time was the sale of the house. Thankfully, that has resolved since we filed our motion. Mr. Ahern decided to essentially play ball and get that asset sold. So that is now gone. So that is somewhat of a moot point. More important and pressing today is parenting plan for these two kids, Archer, who was 11, Fisher, who was 8, as well as some financial support, maybe setting some guidelines for these parties to move forward through a GAL investigation and hopefully get your differences resolved in the meantime through discovery and the like. Starting off, and you saw in my client's initial declaration, come back at submission of her motion, we didn't anticipate that the parenting plan would be really disputed. That is a dispute at this point after we received the responsive materials from the respondent. These kids have largely been taken care of by my client. She states for you that she has done nearly 100% of all activities with these kids. She has been the primary parent, if ever there was one, and there's been very little involvement from Mr. Ahern as it relates to this. My client details for you some of the medical concerns with one of the children who has this acid reflux condition, who also has the ADHD. My client throughout the course of the years would try to involve Mr. and he would largely be basically unsympathetic to that. I would say, get back to me, tell me how the appointments go, and we'll go from there. That's been what they've done, not only with the medical issues, but school, with visitation and such. My client has retained very large primary caretaking functions for these kids, pre-separation and certainly post-separation. My client left the home on June 1st. When she left the home, again, Mr. Ahern had already moved on to another relationship. This person was living in the garage of the home, family residence, prior to its selling. And my client left and now lives in a rental unit in Longview where the kids have their own space, which again is good. But Mr. Ahern, again, never made any requests for this now suddenly joint custody plan that he wants them a week on, week off. My client details for you that it wasn't until he received his materials a couple of weeks ago that was ever requested, as he has largely been into his own type of activities. This is an individual who does like to hunt, does like to fish, does like to get out on his own, does have the new relationship that he's involved with, and spends a lot of his time outside of the children. This is also a man who works a 4-on, 3-off schedule. And again, has throughout the course of the years worked a tremendous amount of overtime, again, taking him away from these children. My client, by agreement of these parties, who again is employed under a schedule working about 28 to 32 hours per week. They did that by design when these kids were born so she could be readily accessible for these children. That's what she's done. And Dad continues to operate not only at his current job, but also has this freeze-dried candy endeavor that he participates in. Where he does that, he sells that on the side and makes additional income from that, which again takes him away largely from activities involving the boys. Client details for you that it wasn't until this summer that he actually took them on a short camping trip, and that's good. We want that. We want the relationship between Dad and the kids, but nonetheless, that has never been the traditional norm in how these parties have operated during the course of the relationship or after the relationship. My client's concerned with this, and the week on, week off, we see that proposed commonly, but that's just simply not going to work in this case. And that takes the kids at impressionable ages outside the comforts of their traditional parent who's taking care of their needs, and who's fostered everything when it comes to the medical appointments. It also puts Dad in a position with that 4-on, 3-off schedule, with the new girlfriend, with the freeze-dried candy operation, with his activities outside of the home that he likes to do largely by himself, delegates all of his parenting responsibility to the new girlfriend. My client is adamantly opposed to that. Certainly, I think that's reasonable given the circumstances. And again, this is a case where
dad who's been minimally involved, even since separating in the spring, just hasn't seen the kids a whole lot. My client tells you in her responsive materials that she is actually proposing a plan that increases his time. And that's just the standard every other weekend, which we're proposing. She's agreeable to more time as can be arranged between the parties. I think that would certainly be good for these kids. I think it would be good for both the parties. But by purposes of putting something down on paper as far as the schedule, that is what she is recommending. Also asking that kids not be exposed to any third-party romantic interests. That bell can't be unrung at this point because the kids know who the new girlfriend is, as she resided semi inside the home with them. She was in the garage, is my understanding. But nonetheless, moving forward, I think just putting a stop to that, letting these kids transition is important. And these are kids who have had a very closely bonded relationship with the extended family as well. And again, that's a benefit for both of the parties involved in this matter. And that's certainly something that should be preserved. As it comes to finances, well, again, if we look at the finances with this, my client does provide you with some proposed child support worksheets. She tells you that she works 28 to 32 hours per week, and she doesn't have any control of her schedule. It's in a dental office. That's pretty much based on when clients come and when they go, whether they show up for appointments. It's usually 4 days a week. And as I told you earlier, that's by design, so that these parties had set that in motion some time ago. Incomes are relatively comparable, again, as evidenced by our proposed child support worksheets, which we're asking you to adopt, which specifically gives dad an income at about $4,600 per month. My client at about $6,300 per month. She again has not received a dime in support for these kids since they separated. And we are asking you to include child support as part of your ruling today and adopt our parenting plan. Again, it's best interest of these kids. It's not what's best for both parents. This clearly looks like a case where dad's suggesting a joint plan out of convenience for him and to avoid any kind of financial exposure to my client. And again, I think that's pretty evident when you read his materials and he states, well, although I did everything I could to disrupt the sale of the home, including so bad that I prevented people from accessing the upper level by cluttering it so bad. My wife.
Objection, Your Honor, that was not in my client's declaration.
I think it was. I think the suggestion was that my client should pay for some of the mortgage payments since June.
I had the idea that was your client.
No, she says not to do that. That's in the information. So nonetheless, I think that suggestion, it kind of flies out the window, considering that he's living there or was living there with him and his girlfriend. That's where we're at. That's the requested relief that we have set forward. And I think that promotes the best interest of these kids and that of the parties as well, gives them much needed stability moving forward in this. If you do want to appoint a guardian ad litem, I think that would be appropriate too, based on the incomes as set forth in our worksheets. Again, approximately a 58-42 split, or we could call that 50-50 and reserve on any offset once full discovery is exchanged and we have a clear picture on financials.
Solder?
Yes, Your Honor. As far as both parents being primary caregivers, my client's declaration lays out very clearly, and mother did not do anything in her responsive declaration to rebut the fact that there was a third live-in adult who took care of the children along with her own children while both mother and father worked. Both parents here traditionally and historically have worked a 4-on, 3-day off schedule. Mother used to work Tuesday through Friday. Father would work Monday through Thursday. Mother had Monday off, would arrange for childcare, would arrange for doctor's visits on those days, but my client was involved in decision-making. He wanted more of it. Father had Fridays off, so when mom was working on Fridays, my client was with the children on Fridays. This has been historic and documented that they both worked a 4-on, 3-day off schedule. As far as my client not being involved in the day-to-day with the children, the submission goes for the bank records that indicates father has historically taken the kids bowling for over a year. He's taken the children hiking. There are pictures of him hiking. He's taken the children fishing. Mother rebuts that.
Ms. Holder.
I could object. This is all information that came in only a couple of days ago after we filed our response. So my client certainly has answers for that, but we weren't able to file that as Mr. got his shot and did not provide any of this information, unfortunately. Would ask you not consider anything that was not properly filed.
Ms. Holder.
Your Honor, it was properly filed as per the local rules. The filing deadlines refer to pleadings, refer to declarations, and the filing of declarations, replies, and responses. These were submissions that support the assertions that were made in my client's declaration and his reply. And also the exhibits were referenced in the first filing by my client in his declaration. And if Mr. Zandy didn't see those, then he could have reached out because Exhibit B was very clearly listed in the declaration.
So at this point, if I look at it, this was a SIR reply is what I'm understanding, correct? Is that what you're saying?
We got the information from Mr. Ahern by way of his declaration on August 20th. We filed our SIR reply. And then in response to that, we started getting the onslaught of information, text messages, bank records, pictures, and the like that we don't get a chance to respond to. So I think Rule 88 is pretty clear on that. Moving party gets the first shot, gets the last shot. Middle shot goes to the non-moving party, which would be Mr. Ahern. You don't get to go back and forth bouncing information to and from. It would also be due 2 weeks before the hearing. So either way you look at it, I don't think it complies with the rule.
Ms. Holder, anything further?
Your Honor, in this case, I believe justice would so require that mother completely disregards finances, saying that there is no community debt that she's aware of, and that is why my client was working or he was historically working overtime hours. That goes specifically to the argument of the financials. And she completely disregards and says that I do not believe the community debts are associated, or these debts are associated with me or the community anyway, but text messages show that she is aware of $70,000 of community debt that she admits to. To not consider those would be, in my opinion, it would be detrimental to fairness in this case. Also, there's been a lot of reference to my client having this new girlfriend, and new girlfriend is going to be taking over the responsibilities. In my client's first declaration that he wrote, he specifically mentions that there was a text between the parties where mother proposed using her parents for childcare, and Mr. Zandy's client specifically said, "What are you going to do for childcare?" And father responded, "My mother, just like your parents, get to look after the children." And she said, "No." There's no indication and no evidence that if Mr. Ahern has a new girlfriend, that girlfriend is going to be primarily charged with parenting responsibilities. That has not been historic throughout the relationship. As far as the debt is concerned and the finances are concerned, my client has historically not worked overtime. The statute says that it may be taken into consideration, but the reason he was working that overtime.
Oh, hold on. I couldn't hear you.
I was just going to say, we're objecting the merits of the case and information that I'm specifically objecting to that came in well late. If we're going to reference text messages, bank records, that should have been part of the reply and response.
Yeah.
That they sent.
So I want to make it really clear in regard to the additional information that was filed, that matter will not be considered by this court. For one thing, I'm looking to see if I even received it. When did you file it, Ms. Holder?
Your Honor, you should have gotten bench copies on the Thursday, and my paralegal is telling me that it is showing up in Odyssey. She did file it on the Thursday as well.
Okay. Odyssey and what my edition is aren't necessarily the same. So when was it filed?
It was filed on Thursday. And it was filed as a bench copy.
I show a proof of service, and I show a child support worksheet for the 29th. I do not have anything that was filed, anything further for the 29th. So
it should be sealed right above.
So I think this is what you're talking about here. So my question at this point is in regard to the financial information. It was filed on the 28th. So I did see that document. I was looking to make sure there wasn't something else. So I did see that information that was filed on the 28th. So my question at this point is, I did review it, and whether or not, Mr. Zandy, you want an opportunity to respond to it. If you do.
I think I could probably do it through argument. It's just, again, I think the whole, in my opinion, is just getting more and more common, and it's frustrating as a practitioner.
Yeah. And I would agree, Ms. Holder, when you file your responsive pleading, this should have been in with it, not after the reply or the SIR reply from Mr. Zandy's. And I would agree, I'm seeing this constantly. I get an onslaught of emails. I get an onslaught of bench copies the day of or the night before, the morning of. It's gotten ridiculous. And I'm Ms. Holder, I'm not trying to say that to you. I'm saying this to all attorneys, that read the rules. Rules are there for a reason. I expect you to follow them. So Ms. Holder, at this point, the court is not going to consider it, was not timely or in accordance with the local rules. So the court will not be considering it.
Sure. My client's declaration, besides the submissions that were put in, lay very clearly that his overtime hours have not been historic. He was doing that to pay down community debt. Mother never addresses the community debt in her declaration other than to say it doesn't exist. She doesn't mention she specifically does not mention the $70,000 in community debt used to pay down her law school, her student loans. It doesn't mention the $3,000 of medical debt that was addressed by father. It also does not address the fact that the work days for both my client and for mother were historically both 4 on and 3 off. She also does not mention the third person who was living in the home that was helping give childcare, other than to call it my client's girlfriend. That person moved out of the home. I am unaware of my client starting a new relationship with anyone. But again, it was historic that both parents were primary caregivers in the sense that they both took care of the children on their days off from work, and they both were engaged. And for mother to come and now say that father has not been involved would be disingenuous. As far as the incomes go, mother works 32 hours a week. That is historic. That is the reason that we put in the amended child support worksheet, was to reflect that, yes, mother works 32 hours a week. We confirmed with her dental office that she can only work 4 days a week, and it would only be fair to impute her income at what she has disclosed. My client's income should also be imputed at what he historically has worked, which is a 4-day schedule, not including overtime hours. As far as the parenting plan goes, it would be in the children's best interest to spend time with both parents. Both parents are free to make childcare arrangements during their residential time. Mother relies heavily on her parents. My client would also rely on his mother. That is fair, and it's in the best interest, as Mr. Zandy said, that there's a close bonded relationship with extended family, and that is both parents' extended family. As far as the child support goes, it should be set, I believe, if the parents are doing a 50-50 split, I believe the standard calculation would put mother's child support obligation to father at roughly $1,540 a month. Mother's declaration clearly laid out that while my client was still living in the home, she did not help out with community bills at all. And she found that she didn't need to because he was still living there and benefited from the community. That's another reason that my client had worked overtime hours, was to supplement mom's income for 2 weeks when she was off work. And that extra income that he had for working overtime came in handy to pay, again, community debt when it came to pay the mortgage, because mother wasn't able to. What is in the best interest of these children is to spend an equal amount of time with the parents, which is a 50-50 split. And it would also be in the children's best interest for financial reasons to impute mother at her 32 hours a week and my client at his 40 hours a week without overtime. If there was a joint parenting plan, she would owe approximately $411 a month to father for child support.
Ms. Holder, in regard to this additional money, you don't seem to have that included.
Yes, Your Honor. The additional money, I believe, is in Part 1 in business income. Tasty Delights brings in around $300 per year, and it is put as $47 in business income in my client side of the worksheets. And bringing in $300 a year for a side business does not take up much of Mr. Ahern's time. And also, from my understanding, the children are also involved in helping him make candy.
Okay, thank you. Mr. Sandy?
And again, I don't think we need to really focus on what's community, what's separate, where those debts went at this point. This is a brand new case. That's something that we're going to need to do with interrogatories, requests for productions to resolve that. So again, listening to the argument about the parenting plan, that seems to be of the utmost importance today. We've got a dad who in his declaration states something or implies along the lines of, well, mom has kept me out and I haven't participated a whole lot because she designed it that way. But then says, well, in court today, I've been just as involved as she was. My client is the one who gives you the information about the medical concerns for the kids. My client is the one who gives you information about waking up in the middle of the night with this acid reflux, cleaning up vomit, and making sure that the child is taken care of. Dad doesn't give you any of that information. My client gives you the situation and information about the medication for the kids related to the acid reflux as well as the ADHD. And she tells you about the doctor. She tells you about what all goes into that. Dad doesn't give you any of that. And so again, to suggest, well, I'm just as much involved as she is without that information is basically just empty words at this point, contradicting what my client has to give you. So I think if you look at that and compare apples to apples, it's fairly clear to see which parent has spearheaded that, again, historically between the parties. And for dad to suggest, and again, it appears that his work schedule is about 6:30 in the morning to about 4:30, doesn't accommodate these kids' school schedules. So who's going to wake up with the kids and make sure they're off to school? Who's going to make sure that they're fed, that they're bathed? It's not going to be dad by design. The difference here is my client goes to work from 8 to 5. She's there for the kids. Dad's schedule does not line up with that. And dad has traditionally worked overtime, regardless if that was to pay bills, and to his credit, that's good. But regardless if that was to pay bills or to help with offset attorney's fees and the like, the reality is historically he has worked overtime, putting my client in vast majority of the care for these kids. Again, who has grandma, my client's mother, help get the kids back and forth to school until she gets home from work at 5, those 4 days a week. That's been the norm. That's been the tradition. We're essentially asking that remain. Dad, again, doesn't provide really any kind of context or any kind of proof of this outside of just saying things blankly and empty words in his declaration. That's our request. We do believe that he's making more than $300 per year at this frostbite business. We do believe that that should be at least considered for now, along with the overtime, because that is historical for purposes of incomes. I think using the approach of just taking year to date through August would be probably good for both. Giving dad a little bit of a kick for that frostbite business, again, is appropriate. And I'm not sure if he gets the overtime built into these 10-hour days or not. My assumption is he might, just for because it's anything over 8. I'm not sure what the union does with that, or if there is a union for him. My client doesn't have that benefit. She's working those 8-hour days. That's 4 days a week, and that's why her hours fluctuate. That's where we're at. I think this is the best interest of the kids. And financially, just like in any other case, we're going to have to work through these debts and these assets and these other things to see where the chips fall on that. But for now, my client's suggestion is an appropriate one.
So here's what I'm going to do based on the files and record and argument here today. First off, in regard to the parenting plan, this is the best interest of the child. It's not the best interest of a parent, and determining what that is. There is some question in regard to it. So I'm going to do something a little different from what both counsel have submitted in regard to their client. The mother shall have primary time, but the father shall have the children from a time workable with his schedule, in the sense of, I don't know what time he gets off of work. But my intent is he can either pick them up after school on Thursday, or if there's a time that works better for when he gets done on Thursday, that's when he will start his time. And that will go until Sunday at 6 p.m. And that will be alternating. And then every other opposite Thursday from the same time that he picks them up on that longer, essentially longer weekend to 8 p.m.
And it says on page 2 of his declaration, Judge, I don't know if this is helpful or not. I work as a machine operator at warehouser Monday through Thursday from 6 a.m. to 4:30 p.m.
Okay. So I don't know how long it takes him, but if the two of you can work that out, I'm thinking 5 o'clock by the time he gets done with work. So pick him up 5 o'clock on Thursday to Sunday at 6.
Every other weekend.
Every other weekend. And then that Thursday, then the opposite Thursday from the same time to 8 p.m. That way the kids can get home, get ready for school for the next day. But consistently, they'll be with dad on Thursday evenings. In regard to the idea of childcare, the parents have a right to decide who their childcare is. I'm not going to get into requiring it needs to be this particular person or that particular person. Bottom line is the parties are going their separate ways. They have separate lives, and there's no showing that there's anyone in particular that is not an okay decision. So that is up to each parent as to what their childcare is during the time that the children are with them or child is with them. No limitations. Decision-making shall be joint. Dispute resolution at this time is court. The custodian will be the mother. And summer schedule as proposed by mom. And I'm just following mom's parenting plan. It's a standard. I'll adopt that. Holiday schedule, I'll adopt mom's. Again, I didn't see anything other than a standard.
Your Honor, I believe mother's doesn't have specific holidays outlined, whereas father's proposed parenting plan for the holiday schedule does.
Hers is outlined on page 3 of her proposed parenting plan that was filed on May 24th. So in transportation, again, it kind of depends on whether or not dad wants to get off earlier and pick up the children from school, or whether he wants to have that later time. I'll try to, hopefully the two of you can figure that out based on his time. But I was thinking the 5 o'clock is what I was looking at. So transportation, children will be exchanged for parenting time, each parent's home or other agreed location, including the home of the whoever is providing the daycare. That can occur if needed. And then the standard moving language. And then in regard to other, I'll just adopt the statements of the mother standard language. In regard to guardian ad litem, the court is going to order a guardian ad litem to be appointed. Who are the next three?
The next three names are Karen Lawrence, Beth Fellows, and Keith Lawrence.
I'm good with any of the three.
Okay, Ms. Holder?
I'm fine as well, Your Honor.
Okay, so that would be Karen Lawrence. And it will be private pay, 50-50. In regard to the child support, this would be effective June 1. In regard to the mother's income, I am going to have it imputed to a 35-hour week. And then in regard to the father at this time, there appears to be a ongoing working of overtime, so that will be included. So I have 69.78 for the father. I did not compute the mother's at 35 hours.
So want me to take her hourly rate, multiply that accordingly.
Correct. In regard to the use of property, now that the house has sold, I don't know if there's more issues or not. There's a list of several household items. I don't know if there were any objections to those, Ms. Holder?
No, Your Honor.
Okay, so that's granted, including the 2016 Subaru Outback. The request for protecting a property, order both parties not to move, take high damage, etc. That's granted. Household expenses. Here's where the court was not real sure what to do, because with the house being sold, that starts to change things. So I'm going to reserve on that part. I think there needs to be some clarification as to what the proceeds are going to be, and then figure out what community debt is remaining. Meanwhile, those proceeds should go into the account, Ms. Holder's account, pending a decision as to what's going to be paid out of there. Meanwhile, each is responsible for their own future debts. Neither party is to change insurance. I'm going to reserve on attorney's fees. Again, I am reserving in part because I don't know what the proceeds are going to be. So that should take care of all the issues.
Presentation on the 23rd.
24th.
I'm sorry, 24th.
Yes. Presentation the 24th. Does that work for you, Ms. Holder?
Yes, Your Honor, it does.
Okay.
There's going to step out real quick before my next one.
All right. Swindell v. Sandana.
Noel McLean appearing on behalf of Tucker Sandana.
All right, so we have Ms. McLean. Do we have Sherry Evil? Yes. Do we have Ashley Swindell?
Yes, Your Honor.
Okay. All right, so let's go first to the guardian ad litem report. The report that I have was filed on August 2nd.
And I've received a copy of the report. I would note that I had also requested a copy of Ms. Evald's file. She has not provided the counseling records for the parties, or the children, or the medical records for for the children. I'm assuming that we need a court order for her to release those. Since I'm representing a party, I'd like to have access to those since it's a matter. I'm assuming it's going to have to move forward to trial, or first, I guess we need to do a settlement conference.
Ms. Swindell, any objections to that?
I don't think so, but I don't understand, sorry.
Want to restate your request, Ms. McLean?
That the court order that Ms. Ewald is to release the copy of the children's and the party's medical and counseling records that she reviewed for purposes of her investigation and the report that she submitted to the court.
Oh, yeah.
Okay. All right. So with that, that request will be granted. Ms. Ewald, you'll have to provide that information.
And I'll prepare a subsequent order to that effect so that she has that in her file to cover her.
Okay. All right. Anything else? I do not have a motion, which I typically will require before I adopt or make any changes based on a report.
And that was one of that would be one of my initial objections, is that there is no motion before the court. I would also object to the unsworn items that are identified as evidence that were filed by Ms. Swindell. Those are clerk's papers 82 and 87. And then I would also object to the basically the sealed personal health care that's clerk's paper 88 because there's no
hold on, let's go through these one at a time.
Sure.
So looking at number 82, it looks like they are text messages.
Yes, but there's also boxes of basically what appears to be a declaration. If you look at the top of the first 2 pages.
I believe they're just explaining what's in the pictures.
Okay. So, Ms. Swindell, when you are filing anything that's a statement, it has to be a sworn statement. And if it's not, so I understand you're just explaining the pictures, but if it's not a sworn statement of what's being seen, then it can't be considered by the court. Okay. So
can you just look at the pictures and just like not read the top?
Well, I would agree with Ms. McLean. It appears to be a form of an affidavit or a declaration. So you're going to have to either comply with that requirement or it won't be considered. Okay.
Okay.
Ms. McLean, what was the next one?
Basically the same objection as to number 87, clerk's paper 87. That's again identified with the title page of evidence.
Okay. So this is similar, Ms. Swindell. Same idea. You'll need that sworn affidavit. Okay.
Yes, ma'am.
As it relates to clerk's paper 88, which is a sealed personal healthcare record, I have no idea who this is from. I don't know as far as what provider this came from. There's nothing that tells me, the name of the facility or the address. So I'm concerned about that. That I don't have those types of identifiers.
What was this?
This is your sealed personal health care records.
Oh, for Jackson?
That's part of the problem, is it doesn't give the detail that would be necessary to identify who the provider is and who it's even having to do with.
Okay.
But you can't tell from just looking at what's in the file. Okay.
Okay.
So again, the court will not be considering it until it has the correct personal identifiers. Ms. McLean?
So the other issue that we've had is that consistently Ms. Swindell will either not serve my office or serve my office with items that don't correlate with ultimately what she files with the court. For example, I was served with a docket notice for August 20th, but she filed a docket notice for August 27th. We only found that because it was on Odyssey. And so my concern is that consistently I'm not being served with the correct or the same documentation and information that she's filing, or I'm not served at times at all. So I don't, this has been an ongoing issue. I guess the only other potential would be for the court to say that there has to be court approval before she files, with verification that she served me the actual stuff that's been filed. I don't know how to rectify that. But this is not the first time we've had this discussion. This has been an ongoing and consistent problem.
So the court's not going to order court review at this time. Ms. Swindell, you have to understand, anything you file with the court, Ms. McLean has a right to a copy of exactly what you file.
I am sorry that happened. What it was a typo, and I rectified it in the following email. What she's trying to get thrown out is the proof that I rectified it in the following email. So she's manipulating and lying.
So
I'll refile that to prove that she's manipulating and lying, but.
So you have to do that, or it won't be considered, bottom line.
Okay.
Okay. So these are legal questions that you can always consult with Cowlitz-Wakayakum Legal Aid. They come, I think, on Mondays, or Northwest Justice Project. Those are the two possibilities that are here locally. All right. So with that, this is in regard to the guardian ad litem report and the parenting plan. Again, I take a motion. I will not make changes without that motion, except in some exceptions to that. That report was filed. With that, anything further at this time?
I have submitted a proposed order to the court. We are asking for the court to award my client $750 in attorney's fees for having to be here. It's not proper. Technically, she did not provide correct notice, and then it wasn't timely notice, which meant that we had to engage in additional communications with all the parties involved and the clerk's office in order to set this matter over so that I could have appropriate time for my client to respond. And of course, my client has responded, which again is time and effort, which means he's expended attorney's fees. I would submit that even if you look at the sufficiency of the information, there's been no showing of a substantial change in circumstances since the last time we were before the court in regards to contempt. So we're asking the court to adopt the order that I've presented to the court and award my client the fees.
Ms. Swindell?
The reason I filed this was because I assumed the court would read, the GAL report and understand what's happening here and do something about it. This is the second court hearing we've had for the GAL report. The first time it wasn't read. The second time, apparently, it does not matter. And this is sad. This is very sad.
But based on the files and record, I will grant the request and sign off on the order. Ms. Swindell, have you seen a copy of the order or not?
Yeah, I saw it.
All right, understanding that's the court's ruling, whether you agree with it or not. Are you okay if I put approved via Zoom?
Yep. Yes, Your Honor.
We will provide a conformed copy of the order that the court has signed. And I guess my question for you is, would you be opposed to just interlineating at 6D that the guardian ad litem shall disclose? Or do you want me to go ahead and submit a subsequent order?
I would rather you go ahead and do a separate order and then just put not approved for Ashley Swindell's signature and then the date.
I just provide it ex parte.
As long as you put on there, send it to my attention And
Okay.
just put that, as she said, she's not approving it, so just put not approved and the date,
Okay.
and then send it to me for my signature.
Okay. And then once that hits Odyssey, I'll provide copies of those to Ms. Ewald and Ms. Swindell. Thank you.
Okay. That's it for today.
Thank you, Your Honor.
Thank you.
Morning, Your Honor. Brady Hornstein here for Victor Escobar.
Hello. Just a second. All right, this is on for temporary order. Sorry, I'm looking for why is this not coming up?
And thank you, Your Honor. Of course, where I do represent the petitioner in this matter, the moving party, Don Felton. Here on my client's motion for temporary orders. Before I get into the substance of my argument, just want to make a couple of preliminary points. This is one where Mr. Bornstein and I discussed a week or two ago, and kind of the difficulties, I think, from both of our positions in this. I knew the case, looked through the file, recognized that there was a motion for temporary orders. There was no declaration. So I filed the declaration. Again, had a good conversation with Mr. Bornstein about getting that out. This is an issue that needs to be resolved today. Agreed that on both of our ends, things might be a little bit tardy compared to what they otherwise would be. I think we both stipulated to that. That's fine. Was a little bit surprised to get the amount of volume that we got on Thursday afternoon. So I don't know if the court's been through, there's a 12-page declaration of Mr. Escobar. There was also lay witness declarations. There was an abundance of information from the Woodland schools, along with text messages and some financial information. I don't know if the court had the opportunity to review all of that, or if it did hit Odyssey. I believe it was served on my office on Thursday. This is a case that certainly merits, I think, full argument and full information to be presented to the court. If the court is going to go forward today, I would like that. I would just ask to be allowed a little bit of leeway on my reply after Mr. Bornstein addresses his client's position. But I would just note that, again, my surprise in the amount of volume we had makes it very difficult to respond to, given the local rules do cite 6 pages on for responsive pleas.
Counsel, anything on that?
I'm happy to be flexible, Your Honor. I appreciate the court's patience with both parties and counsel in this case, and yeah, certainly understand the concerns and will not object to any any additional argument raised in response or in reply.
All right, so with that, go ahead and we'll go from there.
And thank you, Your Honor. The court is aware there's 2 children at issue in this case. There's Ethan, who was 12. There's Isabella, who was 9 years old. These parties relocated from California up to Woodland some time ago. And dad had issues with homeschooling the kids. I'll get to my concerns about that in a moment. Parties agreed to separate in the spring. On that separation, dad goes back down to Fresno. Kids finish out the school year with mom in the Woodland School District, do relatively well. My client is concerned primarily about the parenting plan, and there are very significant issues in this case. I think at minimum, a GAL certainly needs to be appointed to try to get through a lot of this and see where the truth lies and see what's in the best interest of these kids. I think that's probably a given. I think that one is probably agreed. What happened after the kids finished school is the area of concern for me. Dad states with my client, they have communications going back and forth, that he would like the kids for the summer. The parties agree in June. We've given you a copy of that text message that states, okay, you can have the kids for the summer, knowing that they're going to come back in late August. There was some discussion about whether the 17th, the 20th, or the 27th, they were going to come back, resume school in Woodland, and carry on as they had. Dad has the kids. He has them for the course of the summer. There's some hiccups, one of which is when dad comes home, basically takes the kids to go back down to California, makes somewhat of a scene, which is somewhat commonplace for him. Loads up what he wants in the car, walks around in kind of a menacing pose, as he typically does, taking pictures and criticizing my client for the condition of the home, who she is as a person, her care of the kids, her care of herself, and the like. Very critical. Takes the kids. My client is still under the assumption that the agreement is still on, that the kids are going to come back and live with her, that they're going to attend the Woodland schools. And lo and behold, in August rolls around and dad says, nope, the kids are going to stay with me. Takes it a step further, and this was in the last couple of weeks, contacts the Woodland School District, who he's had very significant issues with in the past, dating back as early as last year. Unilaterally pulls the kids out of Woodland, enrolls them for a school down in Fresno, and says this is just how it's going to be. My client goes down there for a visit for one of the kids' birthdays in the middle of August, with the understanding of hopefully trying to reconcile the situation. Dad wants none of that. Dad says, no, as he traditionally does, it's my way or the highway. They're going to Fresno, go home, there's nothing you can do about it. So looking back on this, and again, this is prior to obviously my involvement, this is a case that probably should have been in for temporary orders in June. My client was doing the best she could, was operating on a pro se basis with the help of an attorney to draft papers down in Vancouver. Nonetheless, files it without the declaration, and then everything kind of falls apart during the course of the summer due to Dad's unilateral decision to do essentially whatever he wants with these kids. This is a case where, again, this is kind of historic. My client gives you information and concern about Dad's mental health. We'll get to that in a moment. Substance abuse issues, his demeanor and actions towards the kids. I can tell the court, now this is a case, and we certainly would have put this in reply to his declaration. There is a recording from Dad in which he is literally, and this is as an officer of the court, and the GAL will certainly hear this, preaching to the kids about how terrible their mother is, asking them where they want to live, talking about mom and her friends and the like, lecturing them and preaching at them about how terrible their mother is, making them make a decision. And this is beyond what we typically see. This is complete manipulation. This is complete involving the kids in their mom and dad's divorce. This was done back in the spring. And now we have Dad who says, oh, I don't do that stuff. I don't. And I will tell you the 30-minute recording, again, that was taken proves otherwise, and it will go to a GAL, and there's going to be some insight at that. Again, as an officer of the court, I've never heard anything like it. It's terrible. So the level of involvement of Dad with these kids and the manipulation and the brainwashing of these kids needs to stop. I am asking for a mutual restriction. I don't believe it was in my client's initial parenting plan she filed back in June that says these parents, specifically Dad, does not engage these kids in any kind of demeaning discussion or context about my client, or involve them in the divorce, or make them in a position of power where they get to decide where they want to live. These are two young kids. They deserve to be able to love both mom and dad equally and not be put in the middle of this. And had I had the time to put this in to transcribe this, I'm sure there would have been probably some quite strong comment from the court related to that. That needs to be in there. If we look at these mental health concerns, and again, I think it plays to that and parlays to the fact that we have Dad who we are asking him a full mental health evaluation with the parental risk component. We have Dad who admits and says, yes, I'm a religious spiritual man. That's great. That's fine and dandy. However, his impact on my client, they get up here from California, and what does he do? He alleges that she has demons and evil spirits inside her. He goes forward, takes her all the way to Vancouver, between Woodland and Vancouver, looking for a Catholic priest to perform an exorcism because he is convinced that their marriage is strife with what he calls spiritual warfare. More alarming is the fact that the kids are around for this. More alarming is that he's following her around the house, dousing her with what he deems as holy water, telling her again that she needs to rid herself of the evil spirits, reading scriptures to her again as he follows her in parades throughout the community residence. The kids are privy to all of this and see it. That dovetails with my concerns prior about Dad, again, absolutely lambasting my client in front of these kids and saying all kinds of wretched and terrible things, to the point now the kids are being forced essentially in an act of Dad alienating them from the natural bond of their mother, and that's deplorable. We go further than that, and this is in addition to the exorcism and this type of spiritual oddities that Dad continues to engage in. Dad, prior to that, this was back in California, would sit there and banging his head against walls, inflicting self-harm by punching himself in the face until he bruised, would go through cigarettes and essentially make it a game of how many he could smoke in the dark by himself before getting ill or sick. All as a point of I don't know if this was to prove to my client something, or this was out of self-harm acts, but again, signifies that there's something going on emotionally and mentally with Dad that is unresolved. We then fast forward to some of these other instances. My client details for you this incident with the car, where she gets the kids, knows that Dad is not in the right frame of mind, attempts to leave. Dad puts himself behind the car so she essentially can't go. Again, the same type of derogatory name calling, the put downs and the like, to which point police are eventually called. I'm not sure if it was this incident or another one. Police come investigate. Dad says what? Well, she threw a coffee mug at me a year ago. I can't remember really when, but I want you to do something to her for that. You have something that goes very far beyond what we typically see in these matters. Something that shows not only was the relationship extremely toxic, but Dad is not quite in his right mind. The incident related to the journal. Again, what does that portray? Dad is convinced my client is having an extramarital affair. He begins snooping through her things. He doesn't deny this in his declaration. Looks through her journal, takes the journal, throws the journal up on the roof so that my client has to go and gather that, all because he doesn't like what's the contents of that are, in which my client informs is largely personal, also detailing the toxicity of that relationship. He doesn't do it once, he does it twice. And he tries to justify this in his 12-page response along the lines of, It was negative towards me, and I'm paraphrasing, negative towards me, and I talked about this other person that she was interested in. He spends a significant amount of time in his declaration detailing his concerns about these extramarital affairs. My client denies those, by the way, and using that as a basis to support his actions at the time. Again, a lot of these actions predate this. A lot of these actions predate the time that they even came up to Washington State. That's problematic. More problematic and concerning is we now have the older child who's started to emulate a lot of dad's behaviors with the self-harm because he's learning from dad. And we know 12-year-olds do that. They look to parents and they emulate that because that is the norm. We have this child who's starting to display signs of that. Again, and this is while dad is essentially preaching to these kids, mind manipulating them to the nth degree, villainizing my client and their mother, and all the while saying, well, I've had you the entire summer. I'm going to break the agreement I had with your mom. You're staying up here. I'm not going to consult with mom. I'm going to enroll you in school in Fresno, and she can take it or leave it. It's not our concern. There's no remorse for that anywhere in his declaration. Again, the 12 pages cite, well, she was having an affair. Maybe I didn't handle myself appropriately, but it really wasn't that way. Yes, I'm very religious, but I didn't insist on her having an exorcism. There is some very significant mental health issues going on right now. And again, had I transcribed, which would have taken a while, and been to you on time, the conversation, you would have really seen that would have really hit home. We look at some of these other issues. And again, my client has concerns about the substance abuse. Mr. Escobar smoked a lot of marijuana. And my client details for you that he was high on a daily basis. He doubles down with that with alcohol consumption. My client gives you information related to that. She came home one day. He's passed out or nearly passed out in his car, surrounded by a bottle of wine between his legs and empty alcohol containers throughout the residence. To find out the kids had essentially been charged with caring for themselves while under their dad's care. My client confronts him with that. He wakes up and he vacillates between crying hysterically and laughing uncontrollably. I don't know if that's an impact of the alcohol and the substances or if that's an impact of the mental health issues, but it's very concerning. Very concerning the kids are in there witnessing dad do that. My client details for you, it goes back further than even that. When he was homeschooling the kids, there was issues. This is a man who used to impose his education, his tactics on these kids by spanking them if they didn't give him the right answer. My client details for you that happened upwards of 20 times. During potty training, he would pour cold water on them to try to get them to use the bathroom appropriately. My client raised concerns with this. It's all guys under this control. It's all guys under this domineering impact that Mr. Escobar imposes on not only my client, but his kids as well. And that, again, is of significant concern. We are asking that there be some provisions in the parenting plan related to alcohol and marijuana, that nobody consume alcohol during their time with the kids, nobody smoke pot during their time with their kids or immediately prior to that. I think that's probably best earmarked for dad. I read something I thought in their responsive materials about concerns about my client, but that was mostly related to her relationship. So looking at that, given the issues and the allegations, that probably makes sense. I want to briefly discuss this Woodland School District thing because I don't think there's anything that really you have from a genuine neutral party outside of what we provided you from the Woodland schools. Mr. Escobar took it upon himself to raise extensive amounts of frustration with the school district. He threatened to sue them. He filed complaints. He would transcribe meetings he had with them, all over basis that my client is still a little bit uncertain of. We gave you information. He gave you a stack of information related to that. But it's interesting if you look at what was submitted in an email by Asha Riley, I believe is her name, who was the assistant superintendent, where she details how the staff responded to this, where staff was saying they felt unsafe around him, and where she's saying that his others were highly uncomfortable and that his behavior and communication continued to get erratic. That's problematic. And then we have, again, he leaves in the spring, problem goes away. Kids are finished out the year, only for him to unilaterally pull them out of Woodland without discussing that with my client. That's very concerning. Lastly, I want to talk just very briefly about this house situation. There is a concern expressed by both parties related to that. The incident in June, and where Mr. comes and takes the pictures, sends a upwards of 2-page, 3-page email to my client, detailing and criticizing her about how this doesn't look right, she needs to fix that, all the while not recognizing that she works full-time. She's taking care of 2 kids. She's the one that was seeing them through school between the months of late March and when they finished in June. She's the one that travels down to California to spend a birthday together with them. And to her credit, instead of getting over the proverbial tug of war over kids, she decides not to. She decides to do the right thing, bring it to court, and ask that it be handled the right way. She goes to California for the birthday party, comes back empty-handed. knowing there's probably a good chance to do that, but also recognizing the fact that she doesn't want to expose these kids to any more turmoil that dad's put them through since the spring. Dad continues to manifest that. He continues to breed that. And again, I was concerned in the 12-page declaration he submits, saying, well, it really wasn't as bad as she's saying. She has a tendency to embellish things and then tries to justify it. Now it comes back to what he perceives as her going outside the marriage on. That's a concern. There's nothing about the kids or what's best for the kids. It's about what's best for him. And that's littered throughout his almost 200 pages of responsive materials, justifying himself in the Woodland School District, providing declarations from his friends, which really don't say a lot, giving his account of how he kind of wants things to be walked down and believed, trying to gain sympathy that my client was going out on him in an extramarital affair, which I would tell you is Washington as a no-fault state is largely irrelevant. Spends ample time continuing to rehash the toxicity of the relationship, trying to make himself look clean in the eyes of the law and in this court, all the while not recognizing the impact on these kids. And I will be interested when a GAL is investigating this to get his or her input on that reporting, because it is beyond anything I have ever heard. That's where I'm at with that. As it relates on the parenting plan, as it relates to finances, it looked like we were pretty close on estimating his income. I did receive that information, which shows that he's making about $76,000 a year. We had estimated 75. That puts him pretty close if you use our figures at a gross of $6,250 or a net of right about $5,000 a month. My client, who is employed by Peace Health down in Vancouver, we provided under sealed financial documents, a copy of her pay stub. It shows, and by using the year to date through August 10th, which is how I did that, puts her at a gross of about $84.63 or a net of about $61.82. I realize that's a little bit more than Mr. Hornstein's figures. Regardless, I think we're in the ballpark with those. We are asking.
I'm sorry, net for mom of what?
I've got 61.82.
Okay.
And I will tell you on those Peace Health pay stubs, you'll see total compensation. That is not the accurate box to calculate for year to date, because that includes what Peace Health is providing her by way of benefits. You got to look specifically at what the employee cost is. Nonetheless, we do believe that child support is appropriate. He had the kids for a couple months. She had the kids for a couple months. I'm fine if we start child support at September 1st. Our big concern at this moment in time is getting the kids back to Washington so they can start school with their friends at Woodland in the same district they've been, whether that's part-time through the homeschooling process or that was last year, getting them back home and taking this self-perceived control away from Mr. Escobar. It's having an impact on the kids. Get a GAL appointed. If we need to come back for an interim review, we would be fine with that. We just have very significant concern about what he's telling them and preaching to them about mom and the impact on these kids emotionally, trying to alienate mom, because that's the only thing that really is happening right now. Well, and I would suggest we do that sooner than later. My suggestion was originally for August 29th. That date came and passed, obviously, with the hearing being set over. I would submit this Saturday that they meet in Eugene, Oregon for a transfer.
Response?
All right, thank you, Your Honor. I'm certainly just on a few preliminary items. I think we are in agreement that a GAL should be appointed in this case. If Your Honor determines that's important to do today, we certainly recognize that that's important and inevitable in this case. I think the big issue here is, what do we do with the kids right now? We have this, if you read both declarations, I think any of us reading these as outsiders are certainly concerned and alarmed by what was in these declarations and kind of what was alleged on both sides. So you really have a situation where he said, she said situation. And we have two apparently high functioning professional workers. My client is hired as a teacher at the school district down in Fresno and is already working, which is a regular job, obviously significant requirements. And Ms. Felton is obviously working a regular job at Peace Health. So we have people who, if we just take each accusations of each other, all these are alcoholics and drug users and erratic people, but they also seem to be raising kids and getting to work each day and carrying on their responsibilities. On my client's side, he's demonstrating this declaration that he's provided stable housing. They've rented a home in Fresno that meets the needs for the family and the children. And his concern primarily is almost the exact same that Mr. Zandy has shared. He has significant concerns with Ms. Felton, concerns about her drinking, concerns about her ability to maintain a safe and healthy home environment as demonstrated by those pictures. So we have a number of complicated issues that I think it would be really difficult for Your Honor to decide one way or the other on today. Definitely need some more work from a GAL and some additional evidence and additional responses or review, additional discovery, all of that to really get a sense of what's going on. in each individual's lives and in the homes. But the fundamental question is, what's in the best interest of the children today? They've already been down in California all summer. My client certainly disagree. He sent a letter, an email to his wife earlier in the summer explaining all of his concerns about what he saw when he was back in Washington. So it's based on genuine concern from him about what the home environment is like and what Ms. Felton's ability to care for the children looked like when he was there. So also Ms. Felton's behavior just seems kind of inconsistent with the extreme concerns that she's arguing or raising today, which is, she's essentially saying he's inflicting significant harm on the children, but she did not apparently take any steps, in an emergency manner to try and get the children brought back to Washington sooner. The children are already in school. They've already started a school year. They're already living in their new home in Fresno. My client's already working, and everything is very stable in that environment. Certainly, we'd understand a directive to my client today that he not alienate the children, that he not engage in any inappropriate behavior, about discussing the mother. But I think to make a decision today that the children need to now be uprooted after spending a summer in Fresno, getting started in school, having a stable home environment now, my client already working as a teacher at a public school district, which I think, you don't know for sure, but I think you can presume a certain amount of background checks have occurred and other verifications have occurred before a teacher at a public school is hired about a number of issues. So we encourage Your Honor to certainly set a review hearing. I think that would be appropriate, appoint a GAL, but reserve on some of these decisions. But the major issue today is from our perspective, is to leave the children in Fresno on a temporary basis, allow them to go to school. If this needs to change after Christmas break, or this needs to change for an emergency determined later, or at the end of the school year, that would make sense. But for right now, to uproot them and force them to meet in Eugene this weekend for a transfer, and then to put them back in a home environment in Washington that, frankly, we're just not sure what that looks like either, would not be in the best interest of the children. So I think my client's declaration, it is extensive, does speak for itself. I think he addresses significant concerns that he has with his wife and her ability to parent, her alcohol abuse. It's not just that he's mad that she had an affair. I mean, I think he's just provided a number of facts. This is obviously a very raw situation, as Your Honor knows, in divorce cases, and discussing these things as a way to demonstrate his overall concern about her mental health and her ability to parent and her ability to take these kids and be responsible for them 100% of the time. So he didn't violate any of the laws. I think whether he had a specific agreement or not, I think is an open question. I think he did what he believed was in the best interest of the children, to take them to Fresno and then decide to keep them in Fresno, enroll them in school, and they're doing well by all indications from my client. And I encourage Your Honor to leave the children in Fresno for right now. Happy to answer any questions.
Thank you. For Sandy.
Here's what we know, and here's what I think is stipulated about this. We now have these concerns where he says, well, I don't know about the care of the kids, the stability, the safety of the home. 6 months ago, he had no problem with that. He left the kids in my client's care, got his car, and relocated to Fresno. Reason and logic would dictate if he had those concerns 6 months ago, he would have never left the kids with somebody that he thought was an alcoholic or had these problems or was in an unsafe home. He just up and left. We have the agreement. This is directly from him. My client, I will agree to pick the kids up in August, either the weekend of 8/17 or 8/24. I will decide soon and alert to what works best. They go on talking about some of this other stuff, and he says, what? Agreed. Kids go, they're in California. He shows up in June, basically on a mission to get the kids and then look through and build his case, if you will, knowing that she has filed divorce, takes the pictures, sends the long email ridiculing her, which does nothing else but to bolster his claim in court. Very self-serving, very transparent to see through that. Nonetheless, that was his tactic he took, and then says, I'm going to keep the kids here because I have concerns about you based on the 10 minutes I was there in June to pick the kids up on these pictures that I took. Not helping her clean up, knowing that she's working full-time, not helping her maybe get rid of some of his things. No, he takes a trunk full of things. My client says a gun and a couple other things. He disputes that. Nonetheless, he spends his time taking pictures, takes the kids down to California, and then in August says, well, you can come down here, but you're not taking the kids. Doesn't tell her, like we would expect. The guy sends a 3-page letter about everything she's doing wrong, but doesn't bother to tell her, oh, by the way, I'm going to disenroll the kids from Woodland. I'm going to enroll them in Fresno, and they're going to go to school here and they're going to live with me. I think that's what's best for them. He doesn't even have the courtesy to tell her that. He just does it. And that's the problem with him. He continues to do that. Continues to engage these kids in the conflict. The kids see this. The kids hear this. The kids are actively participating in this. He's treating them like a congregation he's preaching at. He treats them as though they're on a jury and they're deciding their fate come 2 weeks from now. No, that's problematic. So I find it really hard to believe when Mr. Escobar states in his declaration, well, I have these safety concerns all along. That's why I kept the kids. Well, that begs the question. If you have these safety concerns, why did you agree to take them for 3 months during the summer, agree via text message, and then send an email after the fact? This was all done by design. It's very transparent to see that. It's very frustrating to hear the words on this recording It's very frustrating to know the impact that these kids are going to have. And it's very frustrating for him to think, well, that's why let's just get a GL appointed because they've already started in Fresno. They have, and that's to his advantage, and he knows that. Because the court is obviously going to be reluctant to uproot the kids from the school they've been at. They've been in Fresno school for less than a week. They were down in Woodland for a long period, extended period of time with mom. And again, that doesn't register on his radar because he has the dispute with the Woodland School District, which again is undisputed. We are asking these kids to be returned. We are asking a strong message be sent that this type of behavior is not okay, and that these kids should be allowed to maintain the consistency that they've always had in the Woodland home, around their friends, in that school district.
All right. So I have reviewed the files and record, and based on that, the court has significant concerns. No, Mr. Escobar. When a person makes unilateral decisions of how something is going to come out or turn out is completely not okay. Not going to happen. And that's what happened here. The court does not, at this point, this is not about the parents, not about their emotions at the time. This is about what is best for the children and figuring that out. So those children will be returned. They will be returned no later than 7 p.m. on Saturday. That is the 7th, isn't it? Yes. Saturday, September 7. The children will be immediately enrolled back into the same school that they know, have known, in Woodland, Washington. The father had absolutely no right to unilaterally decide to remove those children from that school and from what they knew as home. In regard to the father's visitation, it will be supervised based on his showing of his actions. That will be one time per month. And it will be two-hour visits by a professional supervisor. So there may be some conflict in that. What I said, it's 2 times per month, 2-hour visits, trying to keep it together so dad is not having to come up more than he needs to. In regard to the request for no alcohol, marijuana, or non-prescribed drugs, neither parent is to consume any of that 8 hours prior to or during the time that they have either of the children. In regard to the mental health evaluation with parental risk component, the court definitely thinks that it's necessary, but I want to wait and see whether they both need it or just one. So I'm going to reserve on that at the moment. And meanwhile, appoint a guardian ad litem. Who are the next 3?
The next 3 names are Beth Fellows, Keith Lawrence, and Amy Turnbull.
I'll strike Ms. Turnbull.
Counsel?
Those others are fine. Thank you.
Okay. So that makes it Beth Fellows. That will be private pay, 50-50. In regard to child support, the father's income, if I understood correctly, $49.50 per month net. And then for the mother, $61.82 per month net. And that would be commencing September 1 of 2024. In regard to, I just want to make it clear as to decision-making at this time, it will be limited and only the mother will be making decisions. Dispute resolution will be the court. The custodian will be the mother. Court reserves on summer schedule and holiday schedule. At this point, transportation is going to essentially depend on, now obviously the father needs to get those children back up here as ordered. In regard to the other part, obviously the mother would take the children or have someone take the children to where the supervising visits will occur. Vancouver is okay. Doesn't seem to make a lot of sense to come all the way to Longview since mom is in Woodland too. But either either Calais County area or Clark County area for the supervisor. Mom will make sure that the children get there for that supervised visit. And then the standard language as far as moving with the children will be included. Let me make sure that I have, and then I want it made very clear. Neither parent is to have any conversation with these children in regard to this litigation, this action going on. Children have a right to be children and not pulled into a custody fight. They are not to be talked about in regard to who they want to live with. Obviously, guardian ad litem will have conversations with those children, but the parents are not to talk to these children. And if they hear anybody else talking to these children about it, they are to stop it immediately. Both parents shall be required to keep the other advised of their current residential and employment addresses, as well as their telephone numbers at all times. Essentially, I'm going to adopt what was in the additional paragraphs that were included in the May 24th proposed parenting plan.
And Your Honor, this is Beth Fellows, guardian ad litem. I have been watching online.
Okay, thank you.
Presentation, what works for your calendar, Mr. Hornstein, 2 or 3 weeks?
Yes, any of that's fine.
So September 24, does that work? Is that?
Yeah, that'd be fine.
Okay.
If it's possible to get the GAL appointment order sooner than that, that would be much appreciated.
I'll try my best.
So Ms. Fellows, at this point, you can do an interim, and then this is one I would leave it as to a motion if either parent wants to move to adopt your recommendations.
Okay.
And then
are you setting any particular date for an interim?
I wasn't. I can go ahead and let's see, we're at. Let's go ahead and set an interim for October 29. Does that work for you, Ms. Fellows?
Yes, it does, Your Honor. Thank you.
All right. That's it for today.
Thank you.
Thank you.
All right.
Thank you, Your Honor.
We have Ms. Gilmore. Just a second here. Let me switch my file over. I still show Jennifer Joslin.
She's actually the representative for the child, Lizzie, the other child not subject to this restraining order, but she was served, I believe, with our materials.
Okay. Hold on. Everything's loading very slow today. And I just want to make sure Sarah Jackson, you are previously known as Sarah Counts, correct?
Yes, ma'am.
Okay. All right, counsel, go ahead.
This is actually her motion.
I apologize. Yes, thank you. Go ahead, Ms. Jackson.
I guess I should just start by letting the court know we were unable to still serve Mr. Cahill officially last week. I did finally give up and just serve him via certified mail. Was mailed out on Friday. We filed that service with the court on Friday afternoon, and he should receive that information. It says the first date of service would be today via certified mail. We did try on Wednesday, Thursday, and Friday several times through the day to get him served, but we're unable to get him fully served, Your Honor.
Ms. Gilmore?
Client doesn't want to cause any further delay. I previously advised Ms. Jackson that my office doesn't typically accept service of this type of petition, but we're prepared to move forward today.
Okay. All right. So with that, with the acceptance of service, we will go ahead and proceed forward. Go ahead, Ms. Jackson.
Yeah, so like I had stated in my initial filing, I was very surprised at Neil showing up at our house at about 1:47 a.m. on the morning, the night of the incident happening. He came in, he was very disheveled. He said that he had ridden his bike from his father's house to our house. He stated that there was a confrontation.
Your Honor, at this point, may I voice objection?
Go ahead.
I just simply object to the child hearsay. There's simply no basis or personal knowledge or frankly any evidence supporting this petition, but for these allegations, and I don't think it's appropriate for the court to consider.
So, Ms. Jackson, that's one thing I did see when I reviewed everything is the primary part of what is stated in here is child hearsay. And child hearsay is not admissible. And so
I guess
cannot be considered.
So I guess I don't understand what that is. Could I get some clarification on that?
So there are rules of evidence that talk about what evidence or statements or things like that that can be admitted into the court for court's consideration. And there are rules that talk about what's called hearsay. And you are offering the child's statements for proof of the matter asserted, which is a court rule. It's not allowed. So in other words, you're saying to us what the child said.
Okay.
And that's child hearsay. So anything that the child said can't be considered or argued.
Okay, so I'm not allowed to tell you that he stated that he was choked by his father. I don't understand how I prove that he was choked by his father then.
That's where you would have to consult with an attorney.
Okay,
Can I ask
for an continuance then so that I could try to get an attorney on Neil's behalf, because I'm not sure how I would prove that without being able to enter in the things that Neil had told me. I'm sorry.
Ms. Gilmore?
I would object to a continuance. We were previously before the court last Monday, where Ms. Jackson failed to appear, alleging she had some sort of medical appointment. My client is the primary parent of this child. School has started or is about to start if it hasn't started already, and it's not appropriate for my client to have ongoing no visitation with zero basis. As noted in my client's declaration, this is the fifth request for a restraining order since this case has been pending. All previous have been denied. The child was doing extremely well in my client's home, so I would object to a continuance, and I think that we do need to move forward today.
So, Ms. Jackson, do you have any information beyond what the child said, child's statements?
Well, I have the previous, Mr. Cahill has a domestic violence history himself. He has several convictions for domestic violence. He currently has no contact with our 17-year-old due to the fact that they themselves had a physical altercation. So this doesn't fall outside of a realm of things that have happened previously with other children that I share with Mr. Cahill. So I would say that historically this has happened before. It is not out of the realm of possibility that it did happen indeed this time. I'm sorry that I was indeed scheduled for surgery last week. I did not mean to cause a delay with the court. I'm not meaning to cause any kind of delay with the court now, but I do have to ask for a continuance because in Neil's best interest, I do have to try to do what's best to protect my child. Him continuing to go back to a household where he has the potential, there is a history of abuse, there is a history of Mr. Cahill physically harming and or mentally harming my children. I do have a hesitation for that. I do have a reservation for wanting to send him back there. And I'm not sure what other steps that I could take at this time, as I'm not an attorney. I'm sorry that I don't have the full knowledge. I'm just trying to do the best that I can on my own. So I guess I just need the continuance if I can have one. I'm sorry.
Your Honor, may I respond?
Go ahead.
Regarding the alleged abuse relating to Lizzie, that was contained in a previous protection order that was denied. So she's previously made these type of allegations that were denied before the court. So I think that it's, again, there's zero basis to move forward. And I think if you look to, again, the actual evidence before the court, this child wasn't alleging anything. He frankly was upset that he got in trouble for smoking marijuana, and he prefers to go to his mom's because she doesn't have those rules. And I think that if there was a true safety concern, she wouldn't have dropped him off at my client's house and facilitated the child walking away from the home while my client was actively trying to help.